Good morning. This is the matter of People versus Grant William Boss. Appearances, please.
Tiffany Woods for the people.
Sherilyn Foster Tucker on behalf of Grant Boss.
Okay, I'm sorry. Your name's Sherilyn. Is it Sherilyn Foster Tucker?
Yes.
Okay, very good. Is Mr. Boss here?
Yes, Mr. Boss, can you state your name?
Grant Boss.
Okay, very good. Today's daytime set for a pretrial. This is, I think this is a ticket. So it's file 25S 4576573ST. What's the state of the case?
Yes, Your Honor. I have talked with Ms. Woods, and there is an offer in this case that Mr. Boss would like to take advantage of. Ms. Woods, did you want to place it on the record?
Judge, so he would plead guilty to added count 2, fail to report an accident, with a sentencing agreement for restitution to be reserved, no upfront jail, and referral to probation. And I can tell you that the MCL is 257.622. It's 90 days, $100 fine, and 0 points.
All right. What was the charge originally as?
Failure to, I believe it was a failure to stop at a property damage accident.
That is correct.
All right. Okay. Just bear with me for a minute because I have to find an ROA to write the plea agreement on. Clerk, here you go. What do you want me to do with this?
So that would
Just
be the
write it on there?
last one, so you can either write it on here
Okay.
or we flip to the back and then
Perfect. That's
once
all I
we're
gotta
done
do.
with the back, we add a sheet, so.
Got it.
Yep.
Okay, good. Mr. Boss, raise your right hand. Just swear to tell the truth, the whole truth, nothing but the truth, and the matter now pending before this court?
Yes.
All right. I understand that currently you're charged with failure to stop at a property damage accident, which is count 1, and that the prosecutor is going to add a count 2, failure to report an accident, which is a 90-day, $100 fine and 0-point offense. Restitution is going to be reserved. So the prosecutor is offering you to plead count 2, failure to report an accident. How do you plead to that?
Guilty.
All right. All right. State your full name.
Grant William Boss.
How old are you?
35.
What's your date of birth?
12/8/89.
Okay. How far did you go in school?
Associate's degree.
Good. Do you read, write, understand English?
Yes.
Are you presently under the influence of any alcohol or a controlled substance?
No.
What are you offering to plead guilty to?
Leaving the scene.
Failure to report an accident?
Yeah.
Okay, you recognize that that's a 90-day maximum jail sentence and a $100 fine, and it's a 0-point offense, understand?
Yes.
And by pleading guilty to this failure to report an accident, the prosecutor is going to dismiss failure to stop at a property damage accident. Do you understand that?
Yes.
Do you understand if your plea is accepted, you would not have a trial of any kind, and you will be given up the rights you would have at a trial?
Yes.
Do you recognize that if you're offered to plead guilty to this charge, you've offered to plead guilty to this charge. Before accepting your plea, the court must be convinced you understand the following rights. That if your plea is accepted, you will not have a trial of any kind, and you will be given up the rights you would have at a trial, including the right to be tried by a jury, to be presumed innocent until proved guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to You have the witnesses against you appear at the trial to question witnesses against you. If the court order any witnesses you have for the defense to appear at the trial, to remain silent in the trial, to not have the trials used against you, to testify at trial if you want to testify. If your plea is accepted, you may be given up the right to appeal issues that otherwise be appealable if you're convicted at trial. Further, any appeal from your conviction and sentence pursuant to the plea will be by application for leave to appeal, not by right. If your plea is accepted and you commit any misconduct before sentencing, the court's not going to be required to follow this plea agreement or sentencing agreement. If you break any bond condition, the same thing. Fines, costs, and other obligations due at time of sentencing. Understand?
Yes.
All right. I'm satisfied the defendant understands his constitutional rights and waives same. Now, this plea agreement that you're now offering, it's a result of a plea agreement between the parties, correct?
Yes.
And that plea agreement is the prosecutor's dismissing the more serious charge of failure to stop any property damage accident, which is count one. In the plea, she's offering to permit you to plead guilty to failure to report an accident, which is a 90-day misdemeanor. Understand?
Yes.
All right. Has anyone offered you anything beyond what's in this plea agreement?
No.
All right. Lawyers, is this an accurate plea agreement?
Yes, Judge.
Yes, Your Honor.
All right, both lawyers have on the record confirmed this is an accurate plea agreement. Have you been promised, back to you, young man, have you been promised by the court, the prosecutor, or your lawyer that you'll be put on probation or that you would receive any other specific type of sentence in return for the plea you're now offering?
Only that there would be no jail time.
No upfront jail time.
Yes.
Okay.
Yes.
Now, have you ever been promised that if you pled guilty to this charge, that you'd be treated more leniently than if you exercise your right to have a trial?
No.
All right. Has anyone threatened you or attempted in any manner to force you to enter this plea?
No.
Lawyers, either you aware of any promised threats or inducements other than those disclosed on this record?
No, Judge.
No, Your Honor.
Thank you. Back to you, young man. Are you offering this plea of guilty because you are guilty?
Yes.
Have you reviewed your constitutional rights with a lawyer? Do you feel it's in your best interest to plead guilty at this time?
Yes.
It's your own choice to plead guilty?
Yes.
Okay. Defense counsel, you may voir dire your witness as to the factual basis for the plea.
Mr. Boss, on August 16th, 2025, were you driving a vehicle in Ypsilanti Township, Michigan?
Yes.
And that's in Washtenaw County?
Yes.
And did you get into an accident?
Yes.
And
or theft from a person in a protected class over $1,000. State will ask for dismissal of count 2 in return.
Mr. Gibbs?
Yes,
That's
Your Honor.
accurate?
That is accurate.
Mr. Bureau, they're telling me you're going to change your plea to one count from the indictment. Before we get to your change of plea, I'm required to go over some things with you, okay, sir?
Yes, sir.
How old are you?
49,
How far did you go in school?
graduated.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Gibbs?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
Not anymore.
All right. I have in front of me a document. It's called a change of plea. On the second page, on the line marked defendant, there's a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of theft as a felony of the 4th degree. That carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
In addition to the maximum penalty, you're also subject to a discretionary period of post-release control, which means that if you are sent to prison on this charge upon your release, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison. I do have discretion to place you into community control, what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
At that trial, you have a right to be right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of Mr. Gibbs, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor at your trial. You're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of what are called the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you wish to proceed.
Yes, sir.
Ms.
Your Honor, in addition to the facts that are alleged in the indictment, this.
Oh, Ms. Tranter, I'm sorry.
Oh, sorry. We're interchangeable, it's okay. This offense occurred June 15th of 2025. At that time, Mr. Burr was employed by Miami Valley Gaming, and he took a phone case containing multiple credit cards and $300, which was left at a slot machine by the victim and his wife.
Mr. Gibbs, anything on those facts?
Nothing further, Your Honor.
Mr. Bureau, did you hear the statement that she read?
Yes.
Do you admit and acknowledge what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we went over?
Yes, sir.
And what is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Mr. Buer, I'm going to order a pre-sentence investigation. We'll come back in a few weeks and do sentencing at that time. Are you working right now?
Yes, sir.
Where you work?
Domino's in Oxford.
All right.
It's the only place I can get.
I understand. Well, they tell me you're a veteran,
Yes, sir.
and I preside over our Veterans Court, and I'm interested in having you at least be screened for that if you're up to it. I mean, I'm not going to force you into it at this time, but I think what I would like for you to do is we have our next Veterans Court is October the 12th, which is in 2 weeks from yesterday. And I'd like you to come and just watch and and just at least get it. So you're making an informed decision. Some people, I think you ought to at least take a look at it and just see how it's different. I know, I've looked at your prior record. Just checking the boxes is usually not the right way to approach this. So I'm just asking to at least come and watch and see what it's like.
At least watch. Yes, sir.
Yeah, okay. So that would be November the 12th. It's a Wednesday morning. Be here at 10 o'clock. I will even feed you lunch. Okay?
Yes, sir.
All right, so November 12th, 10 o'clock, be here.
Yes, sir.
Okay? Go back down to court services and schedule your PSI interview.
Yes, Your Honor, I was just asked to address briefly to when, I know that we discussed at the previous get-together or hearing that we had his monitor, and we would make a request request that the court consider that being removed at this point. He has had no issues since the initial issue, and it has caused, as he's conveyed to me, issue with his delivery job. Keeping people asking what it is, kind of causing hassle and frustration for him. His boss was even not giving him deliveries for a while due to that. So again, we would request the consideration of that. We also would request, he is shown to counsel documentation that he is very indigent. We would request a consideration by the court to waive the fees for the monitor.
With regard to the fees, I probably defer ruling on that at this time until sentencing. With regard to the monitor, problem is the notification to the victim. Hang on a second.
Judge, I feel comfortable at this point representing that the victim would have no input. We've been in good contact with the victim, so I'd represent.
No objection then by the state.
Correct.
According to community corrections, he's been compliant on monitor. All right, Mr. Buer, I will remove the monitor today.
Thank you,
Again,
sir.
we'll talk about the fees at sentencing.
Thank you, sir.
All right, and I'll see you on the 12th.
Thank you, Your
Day
Honor.
after Veterans Day, so you shouldn't forget that.
No, sir.
All right, very good. I'll see you then.
Thank you, sir.
Thank you, Your Honor.
All right, Jonathan, thanks.
Reporting the accident?
Yes.
All right. That happened in Washington, or Ypsilanti Township, Washington County, Michigan.
Yes.
All right. Prosecutor, satisfied with the elements?
Yes, Judge.
Okay, very good. Sir, this is your last chance. Are you telling the court you understand what you're doing in offering this plea of guilty, and you voluntarily pleading guilty because you are guilty?
Yes.
Do you understand that the court accepts this plea, that an appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal, not by right, that you may be given up the right to appeal issues that would otherwise be appealable if you're convicted at trial? However, you are entitled to have a lawyer appointed at public expense to assist you in the filing appeal if you can't afford a lawyer. Understand?
Yes.
Do you understand if the court accepts this plea, you're giving up any claim that the plea was a result of promises or threats? Do not disclose to the court during this plea taking process, or it's not your own choice to enter this plea. Understand?
Yes.
Do you understand the court expects payment of all fines, costs, assessments, and restitution time of sentencing?
Yes.
Do you consent to a pre-sentencing conference to be held in your absence with both lawyers and probation in the court prior to the imposition of sentence? In other words, if these lawyers want to talk to the judge, you give them permission to do so?
Yes.
All right. You recognize if you commit any new offenses between now and sentencing, you lose the benefit of this plea agreement. I'll accept your plea, sentence you within the bounds of law. You understand?
Yes.
You a citizen of the United States?
Yes.
All right. All right. I do find pleading this case is freely voluntarily understanding made known and accurate. Court accepts same. This was that sentencing for
December 4th at 10 a.m.
December 4th, 10 a.m. Bonds continued. Does he have to talk to probation ahead of time?
Yes.
Make sure you contact 14B probation, and I'm gonna give you the phone number. It's 734-483-7336. Now, make sure that you call that number tomorrow and make an appointment so they can do the pre-sentence investigation, all right?
Understood.
Very good. See you then. Bonds continued.
Thank you, Your Honor.
Thank you.
Thank you.
Yep. 2025. Court will call People Say Michigan versus Charles Boyce, file 25 FB 1163.
Tiffany Woods for the people.
Good
morning.
Hello, Mr. Boyce. How are you?
I'm
All right.
fine, thank you.
Good. Where's defense counsel?
I'm not sure.
Okay,
He's signing back in right now.
he's signing back in. You talking to me?
I believe so, yes. He should be unmuted now.
Okay.
He's here for
Ca-
Mr. Boyce.
Counsel on Charles Boyce, would you put your appearance on, please?
Good morning, Your Honor. Nick Hanau appearing on behalf of Charles Boyce, and I'm also standing in for Attorney Gregory Sheena with permission.
Okay, very good. Okay, today's date time set for sentencing. Mr. Boyce, you were convicted of operating while intoxicated.
All those having been before the court are near, the Honorable Judge Dave Sessions.
You may be seated. Oh. Whenever I look over there, I never know who's. Ms. Feltes.
Good morning, Your Honor. Actually, Lonnie Feltus for the people. Your Honor, at this time, people would waive any conflict between this honorable court and the honorable defender. We do not believe that any conflict exists to make clear to the avoidance of all doubt.
Thank you.
Assistant Public Defender Hannah Apple, on behalf of Public Defender's Office, our office does not believe that a conflict exists between this honorable court and the Public Defender's Office. If one did arise, our office would waive that conflict. This court could hear this matter.
All right. The court, for its part, also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case of the people versus Carlos Edwards. That's
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
Yes, Stephanie Cannon on behalf of Mr. Edwards.
all right. Mr. Edwards,
Yes,
can you state your name, please?
Carlos Edwards.
Thank you, sir.
I am scheduled to meet with him on Friday at 10 a.m. So I just need a 1 week adjournment to meet with him Friday.
He's in MDOC.
Yeah, he's in, what is it, the SF one?
Excuse me.
Yes,
I would
Mr.
like
Edwards.
to say that I have class in order to proceed with my out date. Can it be Thursday that you can come see me in the court date on the following Thursday or something like that? Because them the days that I have off a class.
When are we adjourning it to you?
There's off days.
Yes.
What?
When are you adjourned?
It would be the 13th. I would give you the 20th if that will help you with scheduling.
Okay, and Mr. Edwards, what, you want me to meet with you on a Thursday? Because I'm here on Thursdays.
Yeah,
At times she is.
yeah. I mean, I'm trying to get this matter taken care of as soon as possible because it's holding me up.
I'm gonna speak with you at 10 a.m. tomorrow, Mr. Edwards. Thank you, Your Honor.
November 20th, 2025, 9 a.m. bond continued. Thank you, sir.
20? Yes.
Yes, on the 20th. All right, thank you. Court does call the case people versus Jacob Halfacre.
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
Morning, Your Honor, Michael Vincent, Mr. Halfacre.
Good morning, sir. Mr. Halfacre, can you state your name, please?
Jacob Halfacre.
Thank you. You'd like this adjourned?
Yes, I talked to him yesterday and he clearly is, he's at the forensic center right now. I'm not sure how long or.
Why don't we do this? December 4th or the 11th? I'm so glad you turned around because.
December 4th, Your Honor.
All right, thank you. We'll adjourn the matter. Is this yes. I'll adjourn this matter then to December 4th, 2025, 9 a.m.
Thank you.
Bond continued. Thank you, Mr. Halfacre.
Thank you.
Where's Miss Cannon? So no, I don't need to talk to her. Just tell her I did not get a green sheet from her. That tell her I'm angry. All right. No, just make up whatever you need to. Court calls case, People versus Devin Lyons Nash.
Jonathan Overwater, Assistant Prosecuting Attorney for the People.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Lyons Nash, who I'm having trouble seeing.
Oh, there. Okay, gotcha. Mr. Lyons Nash, can you state your name, please?
Devin Jeremy Lyons Nash.
Thank you, sir.
Your Honor,
Yes, sir.
this is an adjourned probable cause conference. I have filled out the paperwork to visit Mr. Lyons Nash with MDOC. They have received it. They're doing a thorough background check and I have not passed it yet. But I'm hoping to in the near future.
Do you think you will?
What? That's my most sincere wish, Judge.
I'm just hoping they don't call me.
So I'd ask for an adjournment, and if possible, maybe to expedite this matter, I do have a paralegal here that can hopefully, if after we're done, if he could have a breakout room, we can help.
Are
Mr.
you
Nash.
serious?
Well, no, I don't need a breakout room. I was hoping that he and the paralegal could have one after we're done, and it wouldn't inconvenience anyone.
This is that whole Gretzky thing, isn't it? Is that what this is? You know, there are certain things I don't do.
Yes, I was hoping that, under these
It's like
extraordinary
show causes and that. Why do you continue to do this?
just one of God's little jests. I don't know.
You are not passing the background check. I know it's gonna. It's because of behavior like this. Because the moment I say yes, and I get that the moment I say yes, every one of them is going to want to break up. See?
Well, Miss Cannon just collects them like baseball cards.
November 20th, 2025, 9 a.m. Uncontinued, and no, there will be no breakout room. Nice try.
All right, I'll come visit you as soon as I'm cleared, Mr. Nash. Thank you.
Yes, sir.
2027. Court calls the case, People versus Caitlin Stevens.
Assistant Public Defender Nicholas Bukovich on behalf of Ms. Stevens, who is appearing via Zoom. Ms. Stevens, can you please state your name for the record?
Caitlin Stevens.
Okay. I have before me, she has two cases. I have before me plea forms that indicate she's going to plead to 2 charges of false report of a misdemeanor, which is count 2 in each case. Upon the 93-day offense, upon her successful plea to those charges, count 1 would be dismissed. That is the court's entire understanding of the agreement.
That's correct, Your Honor.
Ma'am, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right. State your name again for the record, please.
Caitlin Stevens.
All right. Ms. Stevens, it's the court's understanding that you're going to plead guilty to 2 charges of false report of a misdemeanor. Those are, as indicated, misdemeanors themselves, punishable by up to 93 days in jail, $500 fine plus court cost. Do you understand that?
Yes, sir.
All right. You also understand, ma'am, that on one of the cases, while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir, I do.
All right, to the charge of false report of a misdemeanor contained in case file ending in 1156. How do you plead?
Guilty.
To that same charge ending, appearing or contained in case number ending in 1001, how do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or had one signed on your behalf?
Yes, sir.
You have any questions regarding any of those rights?
No, sir.
You understand?
Can you pull up me an order setting aside convictions scale in print? I don't know. I don't have one in here. We're see if you have it in there.
And you're waiving all the rights contained in that form, including those under paragraph 5, which are your trial rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
At the
You're not.
moment, no.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
All right, starting in the case ending in 1156, on the date of August 6, 2024, at the Huron Valley Correctional Facility in Pittsfield Township, Washtenaw County, State of Michigan, what'd you do on that date that makes you think that you're guilty?
I falsified a police report.
Say that again?
I falsified a police report of being assaulted in the prison.
Okay. And the information that you provided to authorities was false and you knew it to be false?
Yes, sir.
All right. Going to the other matter, on the date of June 22nd, 2024, at the location of 1880 Ridge Road in Superior Township, Washtenaw County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
Falsified a police report to the police directly of being assaulted at that address.
All right. And you knew that the information you provided to the police was false?
Yes, sir.
All right. Ma'am, if I accept your pleas in this case, I have to advise you that if you commit misconduct as defined in the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, that you would not be entitled to, nor would the court be bound by any sentence recommendation or evaluation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which had led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule and would it be proper to accept this defendant?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2 in both cases. Count 1 in both cases is dismissed. In the case ending in 1156. How long has she been in?
From my understanding, speaking to my client, she's been in since July of 2024. She was not arraigned until September 2025.
And this is not a victim's rights. Ma'am, since this case is mine, is there anything you'd like to say before I impose sentence?
No, sir.
And counsel, any objection to be proceeding to immediate sentence?
No, not at all, Your Honor.
In that case, fines and costs, statutory fees of $125, sentence you to 93 days incarceration, credit 93 served.
On each case, Your Honor.
Well,
one is a 14A2 case, so that would have to be sent in front of Judge Barr.
I'll take the hit. Hey, if he gets upset, I have a feeling he won't. I'll also, on the other case, since it's a 14A case, I'll sentence him. You have any objection to me sentencing you on that case, ma'am?
No, sir, I do not.
All right. Fines and costs of $125, 93 days. Credit 93 served.
Thank you, Your Honor.
So, Ms. Stevens, both your cases are closed out now.
Thank you so much, so I can get the parole board to let me go.
All right. Thank you, ma'am.
Thank you so much. Have a good day.
You too. Can you just inform Judge Barr's office I did that?
Thank you so much, Your Honor.
And then tell him he's welcome. Court does call the cases of the people versus Renee Williams.
I've got the best news of my life. They dropped it.
Good morning, Assistant Public Defender Lauren Penny on behalf of Ms. Williams. Ms. Williams, state your name for the record if you can hear us.
My name is Michelle Williams.
Thank you.
Your Honor, I am referring Ms. Williams for a competency evaluation.
All right. You have the paperwork or you're gonna?
I have the orders. I just need to fill in one more part.
All right. So a forensic evaluation will be ordered. I'll set a competency hearing for January 29th, 2026, 9 a.m.
Thank you, Your Honor.
Bond will continue.
Thank you.
Thank you, ma'am. Court does call the case of the people versus Taylor Byer. And
People.
Good morning, Your Honor. Please, this honorable court. Brandon Bird on behalf of Taylor Byer. Mr. Byer, can you please state your full name for the record?
Taylor Martin Byer.
Good morning.
Good morning.
Good morning, sir. All right, what are we doing?
Respectfully requesting adjournment, Your Honor.
That objection, probable cause conference will be adjourned to November 13th. 2025, 9 a.m. Bond will continue.
Thank you.
Thank you.
Your honorable court. Have a great day, Your Honor.
Thank you. Court calls the case of the people versus Casey Atkins. Is that really it? Is that really it for you?
That really is.
That's so strange.
Good morning, Michael Vincent on behalf of Casey Atkins.
Your name, ma'am?
Casey Atkins.
All right. You're requesting an adjournment of this.
Yes, we are in negotiations.
Okay.
As we speak.
Well, the 20th work?
Yes, Your Honor.
All right, thank you. Probable cause conference, November 20th, 2025.
Good.
9 a.m. She's so nice.
Yes.
So yeah, the people in your office are really nice. They didn't get that from you. Right? Okay, I just wanted to make that clear. Bond, continue.
Thank you, Your Honor.
Court calls the case of the people versus Noah Boren.
And then on behalf of the people,
Good morning, Your Honor. Wade Fink on behalf of Mr. Bowron, who I believe I see is present there in court.
Yes. Your name, sir?
Noah Bowron.
All right. What are we doing?
Your Honor, I have had an opportunity to speak via email with the prosecutor. I've received a substantial amount of discovery, which I appreciate. There are some things I'm curious if they do exist and if I have everything, not by anyone's fault, but just to make sure that everything was turned over. So I would ask for one more PCC, Judge, and then I think we'll be ready to set an exam date if the court.
Not a problem. You want the 13th or the 20th?
I think the 13th is plenty of time. I'm going to get on this and send a list over.
All right. Probable cause conference will be adjourned November 13th, 2025, 9 a.m. Bond will continue. Thank you, sir.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Kaida Matson.
Good morning, Your Honor. Kaida Matson.
Michael Vincent on behalf of Kaida Matson.
I just call this for people.
That was
Either.
absolutely backwards. But go ahead.
Prelim.
I'm sorry, Your Honor.
No, it wasn't your fault. It was Vincent. What are we doing in this case?
You know, it's like home. I get blamed for everything. Feel right at home here. We need a prelim date, Your Honor. We have everything.
All discovery is
Yep, got everything.
Yes, Your Honor.
All right. And oh, okay.
Call me when you are ready.
Okay. Okay, so it's a bit of a strange, where I would set these, they're a bit strange. I can set it on Monday, the 10th, or else it would be set on November 13th.
The 13th would work better. He has another.
All right. Preliminary examination in person will be November 13th. Yes, 2025 at 10 a.m. And that's before Judge Barr.
Judge, we couldn't hear the last.
Barr.
Judge Barr.
Yeah.
Yeah.
I will.
Yeah.
People would have their witnesses available that date. I should have asked. All right. Bond will continue. Thank you. Court does call the case, people versus Winona Harvey.
Kind of Overwater, Assistant Prosecuting Attorney for the people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Harvey, Your Honor.
Ms. Harvey, can you state your name, please?
Can you say your name? No. I can say my name. My name is Nona Harvey.
Oh, wait, what's your name?
I say my name is Nona Harvey.
Okay.
Your Honor. Yep, I did have a chance to meet with Ms. Harvey. I did explain to her, I did not receive any updated competency report. I don't believe Mr. Overwater has either when he and I spoke.
I have not. Well,
the last one was September 23rd, I believe.
Well, actually, the court has received. I did receive one. September 12th.
I think she's been in court since then.
Well, this was from September 23rd, so we're basically at the review and we haven't received anything. Well, the last hearing we had, I have no report.
Oh.
And I adjourned it to today. And so that was on September 18th. On the 23rd of September, we received a report.
Oh, may I approach and have a look at that?
Yeah. I don't like the way they, yes, council can approach. This one's on.
Mayor, can I approach on behalf of Mr. Overwater?
Yes, you may.
Thank you.
Get there.
Send it to Mr. Overwater and Mr. Gandy. All right, apparently we have received a report in this matter. We're gonna send it to council. And then what I would do is I'll adjourn this out 1 week. So probable cause conference in this matter will be set for, is that the 6th? Our competency will be set for November 6th, 2025, 9 AM for council to go through that report. Bond
Thank you.
continue.
I'll come visit you with the report, Ms. Harvey. I'll make sure I keep this case, Judge.
Your attorney's gonna come soon. Okay.
Thank you. Court does call the case, People versus Savannah Bradley.
Ashley Valdes for the people.
Herman Dadish, good morning, Your Honor. Herman Dadish on behalf of Mr. Bradley.
Morning. And your name?
Savannah Bradley.
All right, I have before me a plea form that indicates that the defendant will be pleading guilty to count 3 retail fraud in the 3rd degree, the 93-day offense, and count 4 use of methamphetamine, a 1-year offense. Upon their successful plea to those charges, counts 1 and 2 would be dismissed. There is a sentence agreement of no 7411.
That's correct, Your Honor.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
State your name.
Savannah Bradley.
All right. And I should say on the sentencing form, there's a sentencing judge waiver, but that doesn't need to be filled out because it's on the case.
Yes, Your Honor.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. Is that correct?
Yes,
All right. The first is count 3 of retail fraud in the 3rd degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
yes,
Count 4, also that you'll be pleading guilty to, is use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
yes,
All right. Understanding all of that, do you still wish to plead guilty?
yes,
To the charge of retail fraud 3rd degree, how do you plead?
guilty,
To the charge of use of methamphetamine, how do you plead?
guilty,
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
yes,
You signed an advice of rights form, correct?
yes,
Any question regarding those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal up?
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today to get you to plea?
no,
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
yes,
of your own free will
yes,
and because you believe that you're guilty of these offenses?
yes,
July 20th, 2025, at the location of 3749 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Target store that makes you think that you're guilty?
I put items in a bag, that I scanned the bag, not the items,
Okay, so it was a bag from the store?
yes,
Okay, and you put items inside to conceal them?
Yes.
Scanned the bag, but didn't scan the items inside?
correct,
You did that intentionally?
I did,
And you tried to walk out without paying for them?
yes,
Store was open to the public at the time?
yes,
You didn't have anybody's permission to do that, did you?
I did not.
And these items that you put inside and didn't scan, these were items that were offered for sale by Target?
Yes,
All right. On that same day, did you have methamphetamine in your possession?
I did.
Had you used it?
I did.
Did you know what you were using was methamphetamine?
Yes.
All right. Ma'am, if I do accept your plea to these charges, I have to advise you that if between this time or the time of my acceptance of your plea and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation, nor would the court be bound by that. And you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant?
Defense is so satisfied, Your Honor.
All right, court will accept the defendant's plea guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered. 14A1 probation. Sentencing in this matter will be. No, she's in custody. Thank you. Sentencing, November 12th, 2025. 10 a.m. before me.
Your Honor, may I address bond forward?
Be disappointed if you didn't. Go ahead.
Your Honor, first of all, we had been wanting to ask for a reduction in her bond that is currently set up. Miss Bradley has not seen her son for about 80 days. She was in custody Wayne County for around 75 days. Her son is currently with her dad. She needs to get him enrolled in school before CPS starts getting involved. She is okay getting released on GPS tether, on any alcohol tether, and do any sort of testing that Your Honor decides to order. She's even willing to be put on.
She didn't do that the first time, though.
That was,
I mean, the reason that she's in, she had a PR, she didn't comply with community correction and didn't appear.
yes, understood, Your Honor. And she does have a letter that she wanted to share with you. I've already shared it with the prosecution. I could provide it to Your Honor if you would allow us to. She does apologize for that.
So you want me to stop in the middle of everything and read a letter?
No,
Oh, okay, go ahead.
I mean, I guess I can summarize it to you. It's a really heartfelt letter. She's saying in it that she apologizes. She wants to be able to get back to her son. She's been far away from him enough. She is interested in rehab. I would have asked for her to be released into rehab, except the fact that she does want to be able to go and get her son situated in school. That's the only reason we haven't already submitted that. She just wants to make sure her son is kind of set. He's already late, to get enrolled. But that's what she included in the letter, and she can speak to herself.
Sorry, yeah, I just did the 75 in Wayne County, and I got and came here right the same day. I had to move from my current house to my dad's house. My boyfriend left me when I was in Wayne County. So I got to get him in school because it's about a 30-minute drive from my dad's house to a school that he's having a hard time with. And I just need to get him enrolled over there so he can get in there. His dad currently don't have power at the house. So that's why he's staying with my dad. And he's just having a hard time getting him back and forth to school. I'll do
Wow.
anything.
Pardon?
I'll do anything the court asks.
Well, ma'am.
I know I messed
gave
up.
you the
I know.
Yeah,
I know I
really,
did.
you messed up.
I did.
Big time. And now you want me just to give you another chance to apparently mess up, and you've not received any treatment. You've not received anything, which was part of the reason why you ended up with the bond that you did, and you ended up incarcerated because you were using.
I know.
So, and I'll be honest with you, and I mean, I don't mean to be harsh about this, but I think it's true. I don't know how good you do your son if you're using, and you've done nothing to sort of alleviate that part of the issue.
I don't want to use anymore. I haven't. It's been 80 days.
No addict
But I
that
can do
comes
it.
before me wants to use.
I'm not going to.
Ma'am, how many times have you made that promise to yourself or to others?
Once, I started using in June. It's the first time. I've never done drugs. I never have drug
So
cases
you only
anywhere.
one time previous to what you just stated to me promised that you wouldn't use drugs.
I mean, when I messed up the last time,
You made that promise.
I haven't used drugs in 85 days. And I know I can
Because
do it.
part
I
of that
don't want
we've
to.
had you.
And I'm glad that Wayne County took me, because if they didn't, I probably would still be using. But I haven't, and I feel good that I haven't.
Anything else? I don't need a response from the people. Motion for bond reduction is denied. I may reconsider it after she's evaluated by probation, but at this time, I'm gonna deny the request. Bond will continue.
Understood, Your Honor. Thank you.
Thank you. Court calls the case, People versus Lydia Bevere Whitfield.
Good morning, Judge. Christopher Quinn, appearing on behalf of Ms. Whitfield.
Your name?
Lydia Bevere.
We're just asking for one more PCC, Judge, for discovery purposes.
Probable cause conference in this case will be adjourned November 20th, 2025, 9 a.m.
Could I get the 13th, Judge?
Why?
I'm anticipating potentially having a trial.
Can give you the 13th, but when you can't get out of here that day, don't yell at me.
Thank you.
November 13th. 10 a.m. Court calls case, People versus Douglas Brown.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Morning, Your Honor, Michael Vincent on behalf of Doug Brown.
Your name, sir?
Douglas Brown.
Thank you.
We need a prelim date, Your Honor.
Discovery is all complete. All right. And the people would have their witnesses available. I think the last time, the 13th was a more convenient date for you. So people would have their witnesses available on the 13th.
I believe so, Your Honor.
Yeah, that phone though.
Preliminary examination in person, November 13th, 2025, 2 p.m. That is before me. On continue. Thank you.
Thank you, Your Honor.
Court calls case, People versus Denicia Charles.
Down, Assistant Prosecuting Attorney on behalf of the People. Good morning, Your Honor. Edward Drugas on behalf of Denicia Charles, who is approaching.
Her name, ma'am?
Denicia Charles.
Thank you. What are we doing? Your request?
I'm asking for an adjournment today. There's some outstanding media. That's correct, Your Honor. I agree with the adjournment. In addition, I want to amend the bond to allow victim Brian to have contact with her mom. His mom, her mom.
If you submit an order that's stipulated to, I'm not going to have an issue.
And I also would agree to, there's potential that we're going to dismiss count one, which is the child abuse. So I have no objection to the tether being removed. They're currently working with CPS, the mom and the victim. So we are both requesting that removal. They have allowed contact, no GPS tether, and I can put that in.
Put it all in an order.
Thanks.
How much time did you need, Mr. Durkis?
Like 2 weeks.
Probable cause conference will be adjourned November 13th, 2025, 9 a.m. Bond continued. Thank you, ma'am. Court calls case, People versus Cortez Bryant.
Good morning, Your Honor. Sam Bernstein for Mr. Bryant. I've lost my voice. It's gonna be a long day. I have like 10 PCCs.
Yeah, but it's kind of pleasant. You lost your voice. Sir, your name?
Cortez Bryant.
All right, what are we doing? You're afraid to say anything now. Go ahead.
Can we please set for exam, Your Honor?
Yes,
Discovery is complete.
thank you.
I lost my voice. Obviously. I'm tired. Thank you.
Would the people have their witnesses available? Well, I can set it for the 10th or the 13th.
Could I please have the 13th, Your Honor?
13th?
Yes.
People have their witnesses available the 13th. Preliminary examination in person will be set November 13th, 2025, 9 a.m. That is before Judge Barr. Or I'm sorry, 10 a.m. before Judge Barr. Bond will continue. Thank you. Court does call the case, People versus Rayshawn Dawson.
I'm gonna go grab.
Carmen, I got it.
Oh, okay.
Sam Bernstein, I can stand in for Ms. Foster Tucker for Mr. Dawson.
On behalf of Mr. Dawson on the case ending in 1437.
All right, your name, sir?
Rayshawn Dawson.
All right.
We are asking for an exam, Your Honor.
Well, are you both asking for an exam?
No.
You're asking
I'm
for.
asking for an adjournment, yes.
Okay, let me do the adjournment first. So probable cause conference in this matter, that being the 1437, will be adjourned to November 20th, 2025, 9 a.m. Bond will continue on that case, okay? Then on the other matter, charters on this side. And you don't have Mr. Foster Tucker's schedule.
The 13th looks better, Your Honor.
You don't know that.
I do.
You're just saying that.
No, Your Honor, I have
You're
recounted.
just saying that. You have no idea.
I reviewed the
Because
calendar.
I was going to set it for the 10th. You reviewed it?
And she can make the 10th work as well.
She can? Then
Yes,
why do you say that? Never mind. Don't talk because I don't want your voice hurt.
You're like,
I'm no. What's funny about this is you're not having your, I can come at you all day.
wait till my bond arguments. Just kidding.
So what I'm gonna do, because would the people have their witnesses available to 10?
We'll try, Your Honor.
All right. What I'm gonna do, sir, is I'll set your preliminary examination in person, November 10th, 2025, 9 a.m. That's before Judge Balvo.
That's here?
That's here. Okay. That's on a Monday because of the holiday in the week. All right, bond will continue. Thank you. Court does call the cases of People versus Man Davis.
Ed Rodriguez for Man Davis in 1167 and 1367.
And good morning, Your Honor. Assistant Public Defender Chinazi Carey Akinruli on behalf of Mr. Man Davis. Mr. Davis, state your name for the record.
Man Davis. We all knew.
Judge, you respectfully request that I believe all the matters be set for preliminary examination.
Okay. So all discovery is complete on all of these matters?
To our knowledge,
Yes,
Your
Your
Honor,
Honor.
yes.
All right. And would the people have their witnesses available on the 13th?
We can try for that date, Your Honor.
Preliminary examination in all of these matters will be set for November 13th, 2025, 10 a.m. That's before Judge Barr on all matters. All right.
Thank you, Your Honor.
Bond will continue. Is that it for Mr. Davis? So I won't see him again?
That is correct.
All right. Take care. All right. Court calls the case, People versus Brandon Myers.
Take this call for you. Morning.
Morning, Your Honor. Michael
Ms.
Brady,
Yes.
Assistant Public Defender on behalf of Mr.
Simpson.
Myers.
All right, your name, sir?
State your name.
Okay, he doesn't want to state his. Are you Mr. Meyer?
He's stating his name.
Okay, thank you. All right, what are we doing?
Your Honor, I have to ask for an adjournment. I went to see Mr. Myers. He was not available to be visited when I went to see him. I'll try again. Ms. Anderson from my office asked me to let you know there's a new case that's on the arraignment list today. I don't know if the court wanted to.
Today?
Yeah, he's on the 1:30 docket. It looks like it's a failure to return rental property, 1,000 to 20.
Okay. So what I'll do is I'll adjourn this to the 13th, 2025, 9 a.m. Bond will continue. Can you let the
You go to court on the
magistrate
15th, they got
know
adjourned.
to put this on the 13th? I think that's the
Let
date
know.
they'd land anyway. Thank you, sir.
I'll come visit you, Mr. Myers.
Well, I'll tell you what he said.
Pardon? Okay, he's got it. Court does call the case, People versus Kyle Wilson.
I read that just on behalf of Mr. Wilson, who is approaching. Say your name for the record.
Kyle Wilson. You're requesting an adjournment. Can counsel approach, please?
To get released so he can go back and take care of his children and be able to provide for them. He also has let me know that he has somewhere else to go. He has either he can either go to his sister's house or to one of his children's mother's addresses. Neither of those are in Washtenaw. He's okay getting released on a GPS tether. He has no reason to come back to Washtenaw except for this case. The house that he could go to, his job is in Southfield. And then I believe your sister's address is
Oak Park,
Oak Park, and then the child's mother is in Westland. So really far away from here. Well, not really far away, but far enough. We can do a hot zone tether with a GPS zone that's quite big. He will not violate. He just wants to be able to get back to his job so he doesn't lose it and be able to provide for his children.
Respond.
Your Honor, I'm going to strongly reject any modification of bond. In this case, he originally requested $150,000. He is currently on probation out of the Sixth Circuit Court for a GBH and DB conviction that he pled no contest to. As far as I saw on their website for that case, a bench warrant had been issued at this time. In this case,
Hold on. I just want to make sure I understand it. At the time, the alleged time of this offense, he's on probation.
for a DB, GBH, and DB charge that he pled to.
All right, and there's a bench warrant that's being issued. Was that bench warrant issued in response, if you know, to these charges, or was there something else where he was non-compliant?
I believe it's these, I don't know exactly, it just says order for bench warrant expedited on 10/22 of this year.
If I may, Your Honor.
On 10/22, so that was probably, go ahead, Counsel.
Yes, I believe that's his violation in Wayne. He is in contact with his probation officer. It's good relationship with her. He knows about that. He's complying with that. He was about to be discharged November. He has done everything he's supposed to do. He was ordered to do, anger management classes, and he completed what he was supposed to complete and is still doing more classes on his own, whim. He felt like it was helping him. And again, he was doing very well. He was about to be discharged. He was waiting on the discharge letters.
he was doing everything he was supposed to do except have contact with the police and potentially commit other offenses.
Yes, Your
Right?
Honor.
That's what you meant to say.
That's what I meant.
Go ahead.
He was about another strangulation in this case, and in this case, the victim is extremely terrified because she reported 2 different strangulation incidents, one that was out of county and one in Washington, and that the defendant had left her car for an extended period of time and she wanted it back from errands. He became extremely upset, told her, "Stop telling me what to do or I'll beat your ass." He then balled up his fist, began pushing at her as if he was going to hit her, then pushed her to the ground, which caused her to fall on top of her son. He then had one hand around her throat, one over her mouth. While she's still on top of the child, strangled her. And when law enforcement arrives, he refuses to come out of the house. Officers had to kick in the door, which it was stopped partially by the deadbolt. They eventually were able to kick it open fully and arrest him, at which point he was still tensing up, pulling away. And during these assaults, he had also told the victim, "I wouldn't kill you because nobody's worth me going to jail for life. I've had someone else do it." So I have extreme concerns given that a new strangulation case occurs while he's about to give information for a strangulation case that he pled to. And he's also resisting law enforcement officers at the scene of this event. So I have concerns for the victim, the community, law enforcement, and the high lethality factors in this case. So I would reject any modification of bond at this time.
I just add, Your Honor, that these are just allegations at this point. Yeah.
Yeah, but I'm presuming that some of that we can probably see because the door, there's physical damage to the door.
Yeah.
And while there are allegations, certainly there becomes a problem if all of this is going on and there's a lack of cooperation with police officers.
I don't, again, want to speak to the exact details of the case, but from my review of the video, Your Honor, again, I don't want to get into the details, but it's definitely questionable whether he was resisting arrest or not. In my review of the videos.
In looking at this, frankly, his bond currently is set at $75,000 cash surety. I'm going to deny the request for a reduction. I do find the defendant, having been on probation and then allegedly committing these offenses, to be a danger and risk to the public. Quite frankly, and I did not take their indication of what they had requested as a request to raise the bond in this case. I will decline to do so, although I think that the bond in this court's mind, based upon what I'm seeing, may be set too low. So I'm going to leave the bond where it is. I'll have his bond continue, but I'm certainly not reducing it.
Thank you, Your Honor. Understood.
Thank you. Court does call the case People versus Colette Haynes.
Not the Water Assistant Prosecuting Attorney for the People.
Foster Tucker on behalf of Colette Haynes.
Hello,
Hello,
your name?
Colette Haynes.
Why was Mr. Bernstein stepping in for you?
Sorry, Your Honor, I had another court.
Oh, we would have rather heard from you. Just saying. But go ahead. Anyway, what are we doing?
Your Honor, we're just requesting an adjournment to try and work out a resolution.
Cause conference November 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, ma'am.
Thank you.
Court does call the case of the People versus Marissa Dix.
Good morning, Your Honor. Great to see you. Robert Ellman with and on behalf of Marissa Dix. Ms. Dix, can you please state your name for the record?
Marissa Dix, good morning, Your Honor.
Good morning. Thank you, Your Honor. We'd be asking for an adjournment in this matter. We just need a little time to try to reach out a resolution here.
Probable cause conference will be adjourned to November 13th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continued. Thank you.
Thank you, Your Honor. That sounds good. Thank you so much.
Court calls case People versus John Hacker. John Hacker?
Yes.
All right. Mr. Jerkis is here. All right. What are we doing on this case?
Lucas on behalf of the defendant. I'm asking for a preliminary examination, Your Honor.
All right, discovery is complete.
Yes.
People have their witnesses available. The 10th,
Could we potentially go to the next week, please, Your Honor?
the next week. For all of that, the 7th, the 18th. Is that right?
Yes.
You want to go that far out, the 18th? Any objection, Mr. Jerkus?
I'd certainly like to have it as soon as possible, but if the prosecutor's asking
Well,
for it,
if you want it as soon as possible, that's when it gets set. So do you want the 10th or the 13th? I'll set it for next week, which is better for
I'd ask for next week.
Okay, I know. However, do you want the 10th or the 13th? You haven't been paying attention. Listen, because of Veterans Day, the schedule's kind of messed up. So I have for the where I would set them, I have the Monday, the 10th, and I also have the 13th.
I'll choose the 13th. I'll be requesting
All right.
the 13th.
Preliminary examination in this matter will be set for November 13th, 2025. That's at 2 p.m. That is before me.
For you?
That was a question?
Yes.
Is it?
Yeah.
Didn't I do one before?
Mhm.
Was Faltas not paying attention? Yeah, that's before me. Yeah, I do exams.
True.
Yeah,
Seen it.
I can do those. Is that right? Yeah, thank you, Aaron. 13th at 2. Bond will continue. Thank you, sir. Thank you. Yes, there are 3 judges on that week.
That's what I was thinking.
You and Jerkus weren't paying attention. Court does call the case. Cases of the People versus Cartier Drain.
Middleton Water Assistant Prosecuting Attorney for the People.
This is Public Defender Nicholas Vukovich on behalf of Mr. James.
And Sherilyn Foster Tucker on behalf of Mr. Drains on the case ending in 1685.
Your name, sir?
State your name.
Cartier Drains.
Thank you. And both of you are requesting an adjournment.
That is correct.
Yeah.
That's correct for me.
Okay.
Your Honor, is my understanding in my case, the APA is requesting an adjournment. I know we had a bench conference last time to discuss potential issues in Mr. Drain's case. So I would be asking for the soonest possible adjournment because this is the case that has the most great impact in holding him.
Could the issues be resolved by the 6th in terms of what needed to be looked at? That question was directed to the prosecutor.
I'm sorry, Your Honor.
Go ahead.
I don't know. I don't know the answer to that. But we can certainly try.
Well, here's what I'll do on both of these then, because presumably these cases are traveling together for a reason. I'll adjourn both of them to November 6th, 2025, 9 a.m. Bond will continue.
Yes, Your Honor, may I briefly address bond in the Oda case?
You asked for the nearest date and bond. Go for it.
Sure, Your Honor.
Doing so well.
Sure, Your Honor. Your Honor, I'll be asking for a reduction in bond in my case that the public defender currently represents him on. Today, we did request an adjournment. As the prosecution does need to look into this matter a little bit more, I do understand the need for that. However, this is the case that does have the most severe impact on holding him because in this case with Ms. Foster Tucker, he has a low cash bond. He does have an address at which he can reside at if he is to be released from custody. And he has been regularly appearing at all his court dates in the past. So I do not believe my client is a flight risk. This was prior to him being incarcerated as well. So at this time, Your Honor, I'll be requesting consideration of a PR bond or reduction in bond to another low cash bond.
Give him a PR bond before and then he messed that up. And there was another issue. I mean, not only did he not appear, but There's also what at least may be other violation as it regards this case, right? I mean, that's what needed to be looked into.
Yes, understood, Your Honor.
I'm gonna deny the request for a bond reduction. I'm gonna have his bond continue at this time. I've given him my next available date. They'll look into that and do that. Bond on both cases will continue.
Thank you, Your Honor.
Thank you.
Court calls the case People versus Devon Gilliard. Gilliard? Printing's getting bad. Gilliard.
And good morning, Your Honor, to you and your staff attorney Maxwell Dubin, P number 86012, on behalf of Mr. Galliard, who appears to my right. Please state your name for the judge.
Devon Gilliard.
Okay.
Your Honor, today's the date.
What was your P number?
86012.
Oh, okay, never mind.
What you thought? What do you think I said?
No, I just.
Up or down? Did I talk too fast?
I heard it. No,
Yeah.
no, I heard it.
I talk fast. So.
Mine's a 3, like things like a 2.
I've seen some
Those
ones.
things a 1. Yeah. And you're like an 8.
Yeah.
Wow. Okay, go ahead. I'm sorry.
No, I'm seeing ones past mine now, so I feel a little bit better about it. But
Don't.
Okay.
All right, go ahead.
Savor it. I got it. Regardless, Your Honor.
Your name, sir, if you didn't.
sorry.
Oh, Devon Gilliard.
Thank you. All right, what are we doing?
Today's the date and time set for PCC. I was retained on this matter. I have received discovery. I've not gotten a chance to go through it. I am asking for a adjournment. We are prepared to waive 21 days on the record here today, Your Honor.
That objection. November 20th, 2025, 9 a.m.
I would like to briefly address bond if
He's out. I can change that.
No.
No, okay, go ahead. No, I'm just.
No, I know.
No.
He was in the military, Your Honor, so he's very prompt, upright. So don't.
What
take that.
branch?
Yeah.
Army.
Army?
I'm retired, yes, sir.
You're like 12. How are you?
Medically retired off PTSD, bipolar disorder.
Got it. All right. Go ahead.
Which actually is a great leeway into my point, Your Honor. My client, he understands the allegations and what he's being accused of. That being said, Your Honor, what we are requesting here today is my client does live in Fort Bliss, Texas. His only connection up here is with the victim in this case. But we are requesting.
He lives in where?
Fort Bliss, Texas.
On purpose.
No, he's
No, never mind. Never mind. That was just my statement. Go ahead.
He lives there, Your Honor. Everything he has is there. He has a home there. I'm requesting that he be able to return to that home. He has retained my office. He's been in constant communication with me. He doesn't have a vast criminal history. He has no criminal history of convictions at all. He's not a flight risk nor danger to the community. And he, in theory, would be farther away from the victim, which I believe the court's ultimate goal because he is on tether, is to keep him away from the victim and keep him returning to court, which is all possible. There is one thing on his record while he was in the military. However, there was no conviction, nothing came of it. So he has no convictions either. I don't think he's a flight risk in any way, shape, or form. If he was able to get the opportunity to go on Zoom, he would go on Zoom, but he has also informed me that if he did have to come back in person, he would travel back here in person. And the only other, I know I'm throwing a lot at you, part of my motion is when the arrest did occur, the officers gave his suitcase with his only clothes in here to the victim. He did not want to go back and get that without court order or anything like that. So we're just asking for the one civil standby as well for him to get his belongings from there.
You arrange. The civil standby will be arranged with the police department. So I don't.
Okay, just do that on
anything to do with that.
Okay.
Your Honor, I would have no objection to the civil standby. However, I would have concerns with him going all the way back to Texas, given this case. I would have concerns about him coming back in person for the exam and things. I just have concerns. He does have a past from when he was in the Army with domestic violence. They weren't convictions. They were, I think, adjudicated differently with like maybe classes or something based on what I read. They weren't ended up in convictions though. So I do have concerns given that he would be across the country getting him back here for this case.
Is Texas really across the country?
He's here today with me.
Yeah, because he told him he couldn't leave the state.
Well,
No,
fair.
who is that? Okay. So he doesn't have a residence here.
No, Your Honor, he was forced to get an Airbnb. Am I correct on saying that? He has no residence. He had no connection here except for the victim. No family, no anything.
How long were you in the military, sir?
I did 10 years. Yes, sir.
10 years?
Yes, sir.
Wow. I think I'm gonna let him go to Texas. I think if the military can trust him to fly around everywhere, put his life in danger for 10 years, I think I can trust him to go to Texas and come back when I tell him. So, you prepare an order, counsel, I'll sign it that he may reside in Texas, but he needs to come back for any court date or when ordered by the court.
Absolutely, Your Honor, and that's understand. We appreciate that, and I appreciate you putting your faith in my client as do I. He does have a tether on. I don't know if that's something you want him to keep on or he's able to keep on.
Oh, no, he'll keep the tether.
Okay.
They're used to that in Texas.
No, they can, he's able to.
No, I don't know.
He's able to,
I just said that.
he's able to do that though, right? He can keep the tether on and still go to Texas, correct?
He can go anywhere
Awesome.
if he keeps that tether
Yeah,
on,
yep.
and we will know exactly where he is.
Perfect. Exactly. That goes to my monitor. So thank you. Good to
Thank
see
you.
you and your staff. And I'll see you guys next time.
And you.
And you said November 20th at what time, Your Honor?
9 a.m.
9 a.m. Sounds good. Thank you, Your Honor.
You would think as an 8, he'd be able to retain that for that. Anyway, no,
Sorry to disappoint.
it's okay. I just thought I just make that comment. Anyway, court does call the case of the people versus Tamarian Jones.
Good morning, Your Honor. Sam Bernstein, P75402 here with on behalf of Mr. Jones.
Sir, can you state your name? No, I'm kidding. Can you state your name, please?
Tamarian Jones.
Thank you. That is so.
Your Honor, I think we need to track this case with a co-defendant's case who's requesting an adjournment. And Mr. Jones would like me to address bond if it's.
Okay, so his co-defendant's case, I don't have it marked, is it?
It's Timothy Lacy, Mr. Almond's case.
He's also up this morning, Your Honor.
All right. And so you know that Mr. Elman's case, that's requesting an adjournment?
I spoke with him. That's what he wants to do, Your Honor.
Your Honor, did you ask if we'll be requesting an adjournment in my case?
Yeah, if you hadn't been talking to Bellinger, you would have heard.
My apologies, Your Honor. Yes, we will be requesting an adjournment.
Okay, thank you. Probable cause conference in this case will be adjourned November 13th, 2025, 9 a.m. All right, Esteban.
Your Honor, Mr. Jones is asking the court's consideration for like a 10% privilege and a tether bond. He would submit that it's out of flight risk. He has a home to go to in the community. He was working at FedEx before he was incarcerated, Your Honor. He can assure this court that he will attend all future court dates and stay in touch with his attorney. And he has school as well, Your Honor. Just hoping that the court would consider a 10% privilege.
Response.
Your Honor, this is an armed robbery case. Bond could probably be denied completely. I think
Yes.
that, yeah, any bond is more than reasonable.
Right, I would agree with that. Motion for bond reduction is denied, given that it's capital. All right, bond will continue. Thank you. Court does call the case of the people versus Cassandra Johnson.
As to for the people.
She's in. Okay. Got it.
Good morning, Judge. Christopher Quinn appearing on behalf.
All right, stay seated.
Where's back, sir? Oh.
Sorry.
Stewart, 24F241891. Is Mr. Baldwin in here?
I can get one. Sorry. He was on.
Your name, ma'am? Did you meet with Mr. Baldwin?
Yes,
Oh, okay. Okay, I see. So the defense lawyer is just requesting an adjournment. So let's just do that. I'll get you out of here, okay?
You need them or no?
Now, just tell him I'm gonna adjourn this London Stewart without him. Give me a date in a couple weeks, Lisa.
Judge, what was that?
I need a date on this. So London Stewart, it's a Flat Rock case. They need an adjournment. So would
Okay,
that be 13th?
November 13th at 8:30.
Okay, good
And then the
enough.
one, go ahead, I'm sorry.
No, that's all right. What were you gonna say?
The one that you issued a warrant on earlier because she left, she's at the window upset. You want me to send her down or what do you want to do with her?
Yeah, send her down with the file. She's
All right.
upset. Jeez.
All right.
I don't need anybody's attitude today. Go down the hall and get your notice and we'll see you back here, okay? Thank you. Is Mr. Puta out there? Gurjant Singh Baines, 25R514347. Is he out there?
No, I'm gonna have to give him a call. I don't know what happened to him.
Either.
I think I saw him in the court today, Judge.
Did you?
Yeah, I saw him talking to,
Would you see if he can come in real quick? Sure. Thanks. Francisco Elijah's Cantu. 25F244762A, B, and C. How you doing? Good. Your name?
Francisco.
You're charged with operating while intoxicated, resist, hinder, and obstruct, and continue the delinquency of a minor. You have the right to a lawyer. If you want one, I will give you one. If you want a lawyer.
I talked to somebody earlier, they said that they gave me a number to call. He was talking to Mr. Baldwin.
Well, let's get Mr. Baldwin in here, okay? Sorry about that. Yeah, I'll need that file down here, Lisa.
All right, thanks. Is that all?
All right. Is he coming in?
No, you know what? Yeah, he said he was on signature, but that was a different attorney. It was
Oh.
on. I don't look like him.
Oh, okay. Mr. Baldwin, your name? I need you to start your video, stand, and, unmute.
You need Baldwin?
He's
up. Oh,
He's right here, though. Why isn't he zooming in?
there it is. There it is.
Okay.
Listen.
Mr. Baldwin?
Yes, thank you. Attorney Mike Baldwin, House Counsel, 65417.
All right. And sir, your name again?
Francisco Cantu.
All right. Does he stay in mute, wait formal reading?
Yes, on all three counts.
Not guilty, please entered.
Judge, we're asking for a brief adjournment. I have reason to believe he may be in a position to afford a retained lawyer. I've recommended one to him. We would ask for a brief adjournment so he can explore that opportunity. He is gainfully employed.
Do we know what the breathalyzer or blood draw allegedly was?
I have a paper right here. I did not look at the.
Okay, I don't want you to say anything. I just want to talk to your lawyer right now, okay? I don't want you to say anything against you. $500 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law or ordinance. You must appear in court as directed. You cannot purchase, possess, or consume alcohol or illegal controlled substances. I see what it is. And you are 21, right? Yeah, I have to have you go to AA at least one time a week. We're gonna give you the form. Every time you go, it has to be in person. And every time you go to AA, you have to get somebody to verify your attendance by signing the sheet. Do you understand that?
From here on out, you go to.
Once a week,
Just for your.
just once a week. Okay?
Got something? One moment. Maybe I put the phone out there. Judge, I do believe we're all set. I just want to emphasize that the court has exercised jurisdiction over my client through the arraignment, and the bond is that he is to go to AA at least once a week.
Right, correct. You understand that?
Yes.
All right. Any questions? Okay, go down the,
Well, this is Julian Pluta, this is Melanie Hudson.
this is Judge McNally in 33rd. I need Mr. Puka to log on. We've had this file for an hour or 45 minutes and he needs to log on to 33rd here.
Oh, okay.
Ger-
I'm so sorry, I did not know that.
Gurjant Baines, ask him to zoom in right now if he would, okay?
Okay.
Thank you.
Right now.
Thank you. All right, that's what I'm doing. You're gonna have to fill out a petition for a court-appointed lawyer going forward. Okay, sir? Do you understand that?
And Judge.
If you want one, he said you said something about retaining one, so.
If you come back and you can't afford an attorney, the court officer will give you the form and then you can go.
Well,
Okay.
Lisa, whatever happened to that? You're all
I have
set.
it. I'm just waiting to be done here. Did we give him a date?
You know what? I didn't give, did I, here, John, you know what's going on. Did I give you a date? Oh, I don't think I did either. Well, we can do the 13th, right, Lisa, pre-trial?
Yeah, 13th at 8:45.
More time.
And then I'll
then
run
you
that, I'll run that file down.
Okay, so the 13th at 8:45.
November 13th.
And you can go down the hall and get your notice.
So this prosecutor is only here. Scale of dates, and that's your next date, right? November 15th? Yes. Okay. That's the most time your prosecutors, right? That we might be recording. Okay.
Judge, I was wondering if he wanted that favor with alcohol.
No, he's got it. He found it in the file. You have a nice day. Do. Okay. Judge, I took these to court. I have Miss Garland.
Brianna Garland. Brianna Nicole Garland, 25F244906. Your name, ma'am?
Brianna Garland.
Mike Baldwin, House Counsel P 65417. Judge, today's a date and time set for, this was an adjourned proceeding on the child neglect. We're asking the court to adopt stipulated plea form to a disorderly person.
Okay, this is the one where she already had this one, right? All right.
So on probation, and
So it's not gonna be under 771, but the plea is gonna be to disturb the peace, true?
yes,
Is that what you want to do, ma'am? If you plead to disturb the peace, the child neglect will be dismissed. Do you understand that?
Yes, Your Honor.
If you plead guilty, here the possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes, Your Honor.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring your own, to use the subpoena powers to court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes, Your Honor.
The charge disturb the peace. How do you plead?
Guilty.
All right. Were you at 28514 Walnut Creek Drive in the city of Flat Rock, September 29 of 25?
Yes.
What makes you guilty of this offense?
Judge, may I?
Yes.
Ms. Garland, turn your attention to the date and place as stated and time as stated by your honor. Did one of your neighbors call the police and have them come out to your residence?
Yes.
Okay, is that as a result of one of your children getting out who are underage?
Yes.
And at that point, did the police have to investigate the situation?
Yes.
Okay, defense is satisfied.
Are you on probation or parole now, ma'am?
She is.
Yes.
You understand were you on probation or parole on September 29th?
I think the Heston's date probably predates that incident date, it probably predates this incident.
I don't know what you mean by that.
Sure.
So was she on probation on September 29? I guess is what let me be more clear. Were you on probation on September 29th?
No, I just got it. I just got
Okay.
put on
Anybody
probation.
forced you to plead guilty?
No, Your Honor.
All right, plea is accepted to that charge. I find it to be an accurate plea. Ma'am, I'm gonna have you come up here for a pre-sentence report. I'm gonna let you come here since it's so ugly out there. I'm gonna let you come here tomorrow. Appear
Okay.
by tomorrow, okay? We're gonna
Okay.
give you a sentence date. And also by tomorrow. So you can come here in the morning.
Judge, the stipulated plea form, did you give consideration to fines and costs? Being that she's already on probation.
Well-
CPS is monitoring her home for.
I know, but I still wanna,
Is on the door.
yeah, but I need to,
Yes.
I got it. I
As
mean.
long as you're aware of those factors.
Yeah, I'm not saying I'm not gonna go along with it, but this scares me a little bit. You appear by tomorrow for pre-sentence and you have to go get printed, ma'am. You have to go get printed by tomorrow. I'm filling out an order, so I'm gonna have you go there by 1 PM. Do you understand that? So you should, just do
Yes,
me a
sir.
favor, write this down real quick.
Okay.
You got a pen?
Yes, I do.
734-671.
Okay.
0201. Extension 245. Call the probation department. Make sure that they want to, they want you to come in the morning as opposed to today. I'm good with you coming in tomorrow. You can come in, get your pre-sentence report done, and then go over and get the order from my judicial clerk.
Okay.
And then you take that over to Flat Rock. So Lisa, I'll give her the 13th.
I'll fax the order so she can just go right to Flat Rock.
Oh, so you can just go right to Flat Rock. That's
Okay,
perfect. By
awesome.
what time we gonna do, November 13th sentence, Lisa?
8:30.
At 8:30. Okay, ma'am?
Yes, Your Honor.
All right, I wish you well. Good luck. Any questions?
Nope. Thank you so much.
Thank you.
Thank you, Judge.
Mr. Puda, Gurjant Singh Baines, 25R514-347. Your name?
Good morning, Your Honor. Julian Puda on behalf of the defendant, Jurjant Baines.
All right. I didn't know where you went.
I had to go into another court, Your Honor. Sorry
All
about
right,
that.
no problem. So you're gonna plead to impeding traffic, right?
Correct, Your Honor. I have authority to enter into that plea.
Does he have a clean record or not?
I believe so.
All right, to that charge, responsible or not responsible?
Responsible.
This is just a regular, it's not, oh, yes, it is a commercial vehicle. All right. $220 in fines and costs, and I'll give them until the 7th, okay?
That's fine. Thank you, Your Honor.
November 7th. Have a good day. Thank you.
You too.
Britton,
Bye.
Britton Shante here, 25F-244-795, A and B. Your name, ma'am?
Brittany here.
Come on up here. What? We were not in a good mood today.
No, I am. I did not leave because everything was late. I left because I had to get my son to school.
Okay, that's fine, but understand something. We had a court to school program. We sketched it Flat Rock High. It lasted until about, I don't think I got back here till about 9:40 or so, or 45, I don't know. 9:40. Your case was scheduled for 9:40.
8:40. I have to pay more.
Well, I'm sorry that happened. She told me she rescheduled it.
We mailed a new
sorry.
notice on 10/20.
Yeah, we
Telling her
mailed out a new
9:40.
notice on 10/20.
Got this out of the mail a few days ago, so I mean, maybe it's in the mail right now.
I'm sorry. What do you want me to do?
Nothing. Like I said, it's not personal. It was never personal to why I left. And I
It's
just
fine.
kept anywhere,
It's fine.
You know, so
It's
it
fine.
seemed like they put the warrant out quite fast, but it was not personal. I did not care that you were late. I don't care. I just trying to get this all figured out. I'm trying to get my license back.
Well, we thought you left. Okay, I had people, well, you gotta tell somebody. I had people calling up and down the hall. I'm not a mind reader, right? What do you want me to do? You want me to do this today or you want me to reschedule it?
For it to be done today.
You want a lawyer?
No.
You want me to just arraign you and that's the prosecutor? He's a fair man. I'll send you to him.
Yes.
You want me to do that? All right, so you're charged. Just give me 1 second. I have to white out some of this. Nobody's trying to give you a hard time here. And you're charged with operating motor vehicle while you were unlicensed And that allegedly occurred September 19 of 25 at 12 noon, 12 AM. That is a misdemeanor, punishable by up to 500 fines, 90 days jail. Costs are all those. Do you understand that? And you just sign the advice of rights and read and understand the rights. If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes.
You still wish to waive your right to a lawyer? I'm gonna enter a not guilty plea, $500 personal bond. You don't have to post any money. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. When you didn't show up on October 16th, you went into the default on the civil infraction of expired plate. You understand that, right?
Yes.
Why didn't you show up that day?
I really don't, I don't have an excuse, but I don't know.
All right, go in there, bring the file over, and you can talk to the prosecutor and see what you can work out, okay? You're welcome.
Have a seat.
What is Detective Tulas? Do you have something in here? Detective?
I do, Your Honor. I was notified by Lisa that there would be an arraignment for an MDOC prisoner, Terrion Miller, on his outstanding warrants this morning at 11 a.m.
Is
That's
that right?
Judge Hessen. It's a felony.
that's-
Judge Hessen's doing it.
Oh, that's
Oh,
Judge
it's-
Hessen's.
Okay, so I was in the wrong place. Thank you.
No problem. Thanks.
Have a good weekend.
You too.
I'll let you know when it's ready.
What do you think?
Ma'am, your name?
Something here.
All right, so you met with the prosecutor. He's going to dismiss the expired plate. He's going to dismiss the driver while unlicensed, and you're going to plead guilty to allowing an unlicensed driver to drive. Is that what you want to do?
Yes.
All right, if you do that, the possible penalties on that allowing an unlicensed driver to drive are up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yes.
Did you sign an advice of rights form here today?
I'm sorry.
You read this advice of rights form today. Did you read it and understand it? You understand if you plead guilty, you're giving up all those rights and we're not gonna have a trial. You have the right to a lawyer. You still wish to waive your right to a lawyer. To the charge allowing an unlicensed driver to drive, how do you plead? On September 19 of 25, were you operating a motor vehicle on Telegraph near Vreeland and Flat Rock? You were in control of a vehicle and you knew you were suspended or unlicensed at the time. Is that correct? Are you on probation or parole? Anybody forced you to plead guilty? I'll accept that plea to allow an unlicensed driver to drive, dismiss the expired plate and dismiss the drive while license not valid. I'm gonna listen to anything that you have to say before I sentence you. What would you like to tell me?
That I paid, everything that I did owe for my license. I got my permit and I take my road test on Monday, so hopefully that.
Well, that's good. All right.
Insured, I got, placed on my sister put me on her policy.
Okay.
Maybe that'll help, but.
100 fines, 100 costs, 75 victim strikes, $50 justice suppression, 3 1/4 or 60 days. Can you pay all that today? Yes.
I can pay part of it.
How much can you pay?
Like maybe $50.
All right, when, you want me to set you up on a payment plan or you want,
Yes.
how much per week can you afford?
50.
Okay, you pay 50 now, you pay 50 a week. I'll give you a little bit of leeway time. You start on November 10th, okay? And if, listen to me, if you don't have the money at any point, don't sweat it. Just call the court or come in here on it before the due date, 8:30. Believe me, I'm here. And I will give you an extension. I don't care how many times we have to do it, but if you don't have the money, just don't ignore me, okay? All right, good luck. Thanks.
Corey's on Judge has two in custody, Macomb County and somewhere else. She's getting ready to call his case right now. Jesus. So he hasn't even talked to this guy yet.
What kind of case was that?
Judge,
Yeah.
just so you know, the family just came to the window and posted his bond.
Oh, they did?
Yeah. I didn't know if the attorney had talked to him or not.
He has not yet. He's just got called with 2 in Judge Hessens and could have got Baldwin to do that.
Just told.
Go get.
I was told Corey had it.
Get the, let's get the file and I'm gonna just arraign him and get him out of here. We'll move him out. And then you can take off, okay? So we'll just get, get Mr. Baldwin or whoever else and get the file from Corey, bring him out and I'll go from there. You gotta take, your hat off, please. Are you with the gentleman in lockup?
Yeah.
Okay, the lawyer was gonna meet with him. That's going in front of Judge Hessen. I'm gonna get him out of here. I'm gonna try to find another lawyer. You guys posted his bond? Okay. Let me just, get the file. I'll get him out of here in a minute and we can get rid of him. You can take, okay? Yeah, get him out and we'll go from there. I'll take the file. Let me see that tablet after you log it, please. Lisa, did they post 3,000 or $300?
Yes, they posted 300.
Okay. Let's see here. So that's 3,010%, right? People against Isaiah Marcel West. 25D 234-316. John, you can unhandcuff him. Oh. Your name?
Isaiah West.
All right. What your name?
Dave Schomburger.
Good morning.
Good morning, Aaron.
So listen, we were gonna wait for the lawyer to arraign you. Then I'm told that you posted the bond. Somebody posted the bond for you. So I can do one of two things. I don't want to take your plea unless we're gonna wait for him. The best thing is you can get this reduced if you come back next Tuesday or a Tuesday thereafter. So I can let you out now. I'll set this for arraignment and preacher. I'll just arraign you now. And then I'll give you a Tuesday date and you can show up, but you gotta be a little bit more mature, son.
Yeah, sure.
Okay? So you want me to arraign you and set a court date?
I'm sorry.
I can arraign you, explain the charge and the possible penalties, and then give you a court date. I'm trying to think how best to put it. Or I can wait for you to get a lawyer this afternoon. But he's on the phone with Macomb County, or on Zoom on a case out of Macomb County and another one, and it's gonna take a while. And so it makes sense to me if I just explain the charge and the penalties, continue your 3,000 10% bond, and you show up on a Tuesday. Can you do that?
Yes, sir.
All right. Is that what you want to do?
Yes.
All right. So you're charged with fish equipment, fish ladder, Huron Park, June 2/25, 6:06 PM, a misdemeanor punishable by up to 100 fines, 90 days jail. Costs are all those, and there's a $10 conservation fee. Do you understand that?
Yes.
And you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. You have the right to question their witnesses, bring in your own, use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand me?
Yes, sir.
All right, so you wish to waive your right to a lawyer now, at least until you come back for the pretrial?
Yeah.
And I'll enter a not guilty plea. I'll continue your 3,000 10% bond.
Yeah.
Who's with you here?
That's my mom.
Well, maybe your mom needs to have a conversation with you because you're acting awful immature. You got a warrant out of Taylor, Romulus, Taylor, and another one out of Taylor. And you didn't show up on this case twice. Now, look, you want to go through life acting like this? Well, buy yourself a pup tent. And you can take it over to the Frank and Poet Drain over there, and you can sleep over there because that's where you're headed. You work?
Yes.
Where?
Seal sack.
Why aren't you showing up in court? Who do you think you are?
Think I'm getting.
Well, then why didn't you show up in court? You act like this isn't a big deal.
Truth be told, I'm scared.
Well, I don't want you to be scared. I want you to show up in court.
Jail, anything.
Well, I think I'll let you on a secret. You're almost guaranteed to go when you keep ignoring judges like this. You understand what I'm telling you, son? You cannot do this. I'd go over there and take care of those cases pronto, Mom. Do you want to come this Tuesday? And the following Tuesday?
As soon as possible. It doesn't matter. I'll be here, whatever date you said, I'll be there.
Lisa, do we want to do this Tuesday, the 4th?
That's fine.
Yeah, I put it on the front.
Oh, I'm sorry. We'll do it at 10:30 on the 4th, okay? Go down the hall, get your paper notice. If you want a court-appointed lawyer, you can fill out a petition for one, but I have a feeling it'll work out. Good luck. Thanks. Thanks a lot. So he posted. All right, I'll be back.
Ms. Johnson.
Okay. She's not here. She was in Wayne County. Our indication is Livonia PD picked her up. And so we don't know where she is now.
Understood, Judge.
I did not know, Your Honor. My last information was that she was still in Wayne.
It's Halloween. That happens in Livonia.
Is that right?
No, I'm kidding. I'm
Oh my
kidding.
goodness.
I'm kidding. I don't even know why I said that. All right. All right. So let's try to figure out where she is. I'll adjourn it out.
I have another PCC on the 13th, Judge.
I know because I was setting it for the 20th and you made me set it for the 13th. I recall that, Quinn.
And I'd just like to make sure I'm on time at your court. So that 13th.
November 13th,
Thank you.
2025, 9 AM.
All right, thank you.
Bond continued. Just was rubbing my face in that. The other one was set for the 13th. In case you forgot, Judge, because you're old. Court calls the case, People versus Timothy Lacy.
Good morning again, Your Honor. Robert Ellman with and on behalf of Mr. Lacy.
Your name, sir?
Good morning, Your Honor. Timothy Lacy.
All right. And this is the co-defendant of the other gentleman.
That's correct, Your Honor.
Correct, Your Honor.
I'd adjourn, grant the adjournment. Probable cause will be adjourned to November 13th, 2025, 9 AM.
Thank you, Your Honor. May I address bond?
Have at it.
Thank you. Your Honor, Mr. Lacy's bond is currently set at, I believe, $150,000 with no 10% privilege. What I'd be asking for is a 10% privilege. He is the father of 3 young children. He's the sole provider for his family. He has strong ties to the community. I actually spoke with his mother this morning, who's very supportive of him. He has a home in the community to go to if released on a tether. He runs his own business. He also works part-time at Habitat for Humanity and is also enrolled through WCC for HVAC trade school, Your Honor. And so I believe that based on his community ties, a 10% privilege would be appropriate. And Your Honor, I'd also note that part of the request for this adjournment, I'm not faulting the prosecutor's office, but I don't have discovery yet because I was newly retained. And so that's part of the reason for the adjournment, that of course now, if there is no bond reduction, Mr. Lacy would be in custody. And so I'd be asking for, Your Honor, at least a 10% privilege on this matter. Unlike the co-defendant, Mr. Lacy is only charged, I believe, with unarmed robbery in this matter. So it is a different charge. And I think the bond consideration should ultimately be different.
That is correct, Your Honor. This person is charged with unarmed robbery. I'm going to be revisiting that as I evaluate taking these cases to preliminary examination and trial if necessary. I will let the court know that at the time of this offense, the defendant was out on bond for a domestic violence related malicious destruction of building charge, wherein he is alleged to have destroyed the window of his child's mother's house. So he was already on bond with bond permissions not to be in possession of any weapons or to engage in any criminal activity, and then was involved in this robbery incident. I do believe that the bond that's currently set is more than fair. I'll let the court know he does have a prior juvenile adjudication for assault with intent to rob while armed.
Anything else, Mr. Chairman?
No, Your Honor. Thank you for listening.
Given all of that, I am going to deny any reduction in his bond. I'll leave his bond as set. The bond will continue in this matter.
Thank you, Your Honor. Thank you, Your Honor.
Thank you, sir. Court does call the case, People versus, is it Haitham Al-Shalabi?
Under Hannah Apple, here on behalf of Mr. Al-Shalabi. State your name for the record, please.
Haitham Shalabi.
Your Honor, we're asking that this matter be set for preliminary examination, please.
Discovery is complete.
Yes.
People have their witnesses available on the 10th or the 13th. Which would you prefer?
Can we do the 13th, Your Honor?
Of course you would say.
Thank you.
Preliminary examination in this matter will be set in person November 13th, 2025, 2 p.m. That's before, well, no, I'm sorry, 9 a.m. 10 a.m. before Judge Barr.
Okay.
Thank you, Your Honor.
Thank you.
Thank you.
Bond will
Thank you,
continue.
Honor.
Thank you, sir. Court calls the case, People versus Spencer Norton.
That's calls for people.
Edward Drucas on behalf of Spencer Norton.
Your name, sir?
Spencer Norton.
All right.
Your Honor, I'm asking for 2 weeks. I'm waiting for some video discovery.
Without objection, probable cause conference will be adjourned November 13th, 2025, 9 a.m. Bond will continue. Thank you, Mr. Norton. Court calls case of the people versus Malik. Can't read their writing. Al Sadie.
People. And Stephanie Cannon on behalf of Mr. Malik Asadai. And could you state your name for the record?
Malik Said.
Oh, yeah, you have to keep your hands out of your pocket. Your Honor, we are adjourning this for plea negotiations on my client's behalf. We're asking for a 2-week adjournment.
Probable cause conference will be adjourned November 20th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you.
What do you think here?
Court calls case people versus Terrence Smith.
I should call this for people.
First Lucas for Terrence Smith.
Your name, sir?
Terrence Smith.
All right, I have before me a plea form. Plea form indicates that the defendant will be pleading guilty to the charge of use of a controlled substance, a 1-year offense. Upon his successful plea to that charge, well, the counts are wrong then. He's actually pleading to count 3, not 2. Of use of a controlled substance, the 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would then be dismissed. That's the court's full understanding of the agreement.
The Overwater
Is that
Assistant
correct?
Prosecuting Attorney, that's correct, Your Honor.
Your Honor.
May I have him sworn?
So, for the testimony you're about to give, be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Terrence Smith.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that?
Yes, sir.
All right. Understanding that, you still wish to plead guilty?
Yes, sir.
I do have to advise you that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in 14A2 District Court. You understand that?
Yes, sir.
Sir, to the charge of use of a controlled substance, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or went over that with counsel?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
You'll see on the podium, please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will.
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
I don't know where my complaint is, but let's find it. On the date of September 8, 2022, at the location of 505 South Huron Street, City of Ypsilanti, Washtenaw County, State of Michigan. Did you have fentanyl in your possession?
Yes, sir.
Had you used it?
Yes, sir.
Did you know what you were using was fentanyl?
Yes, sir.
All right. Sir, if I do accept your plea, I have to advise you that it's between the time of my acceptance of your plea and the time of sentencing. If you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or inducements which have led to this plea?
None that I'm aware of, Your Honor.
Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 3, and I have amended or corrected the form to accept this plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
November 12th at 10 a.m.
12th,
Yes.
November 12th, 2025, 10 a.m.
Yes.
10 a.m. before Judge Barr.
Thank you, Your Honor. If I can address bond.
Yes, you may.
Your Honor, he was remanded last week. He was testing at community corrections. Got a positive test. I met with him yesterday. I think he has the understanding and he gave some explanation last week of what happened. He's asking that the court reinstate his bond as a PR bond, allow him to go back to community corrections and test. And obviously he's going to have to continue to test negative all the way up until sentencing. That may have a bearing if he's going to test positive with Judge Barr between now and sentencing. So I'd be asking for a PR bond.
I'm going to deny your request. I will indicate I'm going to leave that to Judge Barr after probation sees him within the next few days, and certainly they can make a recommendation to Judge Barr regarding his release in this matter, but I'm going to deny that request. His bond will continue at this time. All right. Thank you. Court does call the case of People versus Kristen Anthony.
It's Stephanie Cannon on behalf of Miss Anthony. But not with, Your Honor.
Really?
I
went almost the whole morning without a bench warrant.
And you could continue. It would. We could just adjourn this. It would. I'm asking. Maybe. No. And how, good morning to you in court, Your Honor. Yeah, I saw that.
Yeah, you did.
I did.
Okay, go ahead.
Just asking for the adjournment.
Yeah, okay.
Yeah. Are you?
Bench warrant will issue for defendant's failure to appear.
Thank you, Your Honor.
Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately.
25,000, thank you.
Yes, ma'am.
Thank you, Your Honor.
Court does call the case People versus Robert Barner.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Morning, Rob J. Kill on behalf of Mr. Barner. Robert, would you say your name for record?
Robert Barner.
Judge, today's time date for a PCC in this matter. We're asking to set this for a preliminary exam.
Discovery is complete.
99% of it, Your Honor.
There's one report, Your Honor, that's outstanding. I have requested that from the OIC.
One report?
There's a police report that describes the initial stop.
Okay. Well, I'm going to indicate that discovery is complete except for the initial stop report.
That's correct, Your Honor.
If we don't have that, that's not going to be a basis for adjournment.
We'll have it, Judge.
All right. And, oh gosh, it's Kilowald. This is going to be really complicated. I have 2 days, Mr. Kilowald, that I'm going to set it. I can set this. I can set this for the 10th if the people would have their witnesses available, or I'd set it for the 13th. On that date, I have two times. Because as I was explaining to Ms. Faltez, I too also do prelims. So
2 p.m.
Does it make it? Which day? They're both in the same week. Judge, can we go on the 13th? You being the kind and considerate.
People have their witnesses available to their.
See no reason why not.
All right. Preliminary examination in person, November 13th, 2025 at 9 a.m. or at 10 a.m. That's
you,
before
Judge?
Judge Barr.
Judge Barr. Thanks, Judge.
Ron, continue.
Appreciate your consideration.
Thank you. Court does call the case of the People versus Santana Arlington.
Nash Feltus, People.
Morning, Your Honor. Assistant Public Defender Chelsea Vergils with and on behalf of Santana Arrington, who appears via Zoom. Ms. Arrington, please unmute and state your name.
Hi, Santana Arrington.
Thank you.
Your Honor, we're just asking to adjourn briefly for a plea discussion.
Conference November 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, ma'am. Court does call the cases of the people versus John Devine,
People.
all three cases.
This Public Defender Natalie Pate with and on behalf of Mr. Devine, who is approaching. State your name for the record, sir.
John Patrick Devine.
Thank you.
Thank you, Your Honor. As to all three cases, I'm requesting an adjournment. We did receive the discovery in the most recent case yesterday, but I still need to review it and then review it with Mr. Devine.
Okay.
And I'm also asking, to address bond when appropriate.
I will adjourn probable cause conferences to November 13, 2025, 9 a.m. As to bond.
Thank you, Your Honor. I'll start out with the bad fact, so to speak. So Mr. Devine does have three cases before Your Honor. One of them is a 2022 case that he was bench warrant status for failing to appear for a probable cause conference back in May of 2023. I asked my client, frankly, why he missed court that day, and he advises that he does have a traumatic brain injury, and frankly, he forgot about court. I asked him moving forward, if he was released, how he would get back to court, and he advised me that he had a case manager through Michigan Ability Partners. I was personally able to speak directly to his case manager. Her name's Wonder, who advises that she does work with Mr. Devine. And then she also mentioned that she's had no problems with him and he's a nice guy, which of course didn't surprise me. But she also advises me that not only can she work with him to remind him of his court dates, she can also arrange rides for him to get here to court. She also advises that through this MAP Ability Partners, he does receive the housing voucher that covers his full housing and utilities. He does stay at an apartment, I won't say out loud, in Ypsilanti, that the court should have the address. He resides there by himself. His case manager, Wonder, also stated to me that she has been discussing and working with him about getting an application in for him to get SSI. So that being said, I do believe he has a good support system in place to get him back to court. Two of the cases are possession related, and he does understand that if released, he would likely be ordered to drug test and has no issue with that. I did speak to his case manager as well, that I would advise her what court, any bond conditions, so that she can help get him on the path. I'm
How do you
asking,
come into custody?
I believe one of the newer cases, Your Honor.
So there was another offense and then that brought him on the other ones that he hadn't appeared on.
Other one he hadn't appeared on, correct, Your Honor. And the only thing I would like to add is his bonds is currently set on the case that he was in bench warrant status on. It's set at $2,000. And I believe the other matters in front of Your Honor said it's $1,010%, so effectively $100. We're asking if he'd be released on his own recognizance.
I don't need a response, given that he was picked up on new charges. I get the circumstance that he's in, but he's picked up on new charges that brought him on the old charge. The court's going to decline it this time to reduce his bond. So his bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Anitha Barnes.
John Thorberwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender, Magistrate Akinwumi, Your Honor, on behalf of Ms. Anitha Barnes, she should be on Zoom, Judge. Barnes, could you state your name?
Yes,
Anitha
I think she
Barnes.
is. State your name, please.
Anitha Barnes.
Thank you.
Judge, we'd like to set this matter for preliminary exam, please.
Really?
Yes.
Okay. Discovery complete?
To our knowledge, Your Honor.
Okay. Would everybody be ready on the 10th?
I'm aware of no reason why we couldn't.
10th should be fine with us, Judge.
I was asking.
You weren't.
But no. Preliminary examination will be set November 10th. That's a Monday. That's a Monday, 2025. That's 9 a.m. before Judge Valvo. Bond will continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Ms. Barton. Court calls case, People versus Stephen Kimura.
Stephanie Cannon on behalf of Mr. Samora, who is approaching.
Your name, sir?
Stephen Kamara.
Thank you, Your Honor. I did email this morning to the prosecutor's office, our request for inpatient treatment. In his felony matter before Judge Mood on Monday, she agreed to release him to long-term inpatient treatment. And I am asking if the court would be inclined.
Would match that. Yeah, I'm
As
not
well.
gonna have a problem signing that if he wants to.
Okay. Your Honor, outside of that, we did receive discovery. I want to show it to my client. We got the video evidence that we needed. I do need to show that to my client, so I am going to ask for.
When you guys are preparing these orders, and I told you
What do you need?
that I certainly don't do that, he would be released, but it would be on a tether.
Your Honor, however he gets released to inpatient treatment,
Okay,
he
but
will be released to
you can
inpatient.
prepare a new order just indicating that language in it.
Yes, I can redo it, Your Honor, and get it to the court.
All right, so what do we want to do on this case?
Your Honor, we're just going to ask for an adjournment. I do want to go over that evidence with him so he can decide whether or not he wants to waive or set it for preliminary exam.
Grant the adjournment, probable cause conference, November 13, 2025, 9 a.m.
Thank you so much, Your Honor.
Bond continue. Thank you. Court calls case People versus Nathan Burgess.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
The judge, Portia Houston, Assistant Public Defender on behalf of Mr. Burgess. Mr. Burgess, please state your name for the record.
Yes, Nathan Burgess.
Thank you.
Portia, that up. We have awoken the sleeping giant. Go ahead, sir.
Thank you, Judge. I am here. I have spoken to my client and to Mr. Overwater. We are in discussions on an offer on this file and a potential resolution. I'd ask for a 2-week adjournment and hopefully we'll get it wrapped up, Judge.
Oh. Probable cause conference in this matter will be adjourned to November 20th, 2025, 9 a.m. Bond continue.
Thank you very much.
Thank you.
Thank you, Your Honor.
Court calls case People versus Marcus Napier.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Napier, who is approaching. Please state your name for the record, sir.
Marcus Napier.
Thank you, Your Honor. I have discussed this matter with my client, and I believe discovery is complete with the exception of the 911 call that is on the way, and I did discuss this with the people. I would be asking to set this matter for preliminary exam, understanding that if for some reason we don't have the 911 call by then, it wouldn't be the basis for an adjournment. Excuse me. Sorry, sir.
And I found that, Your Honor, they usually come pretty quick.
Do either witnesses available on the 10th?
We'll try.
Preliminary examination in person will be set November 10th, 2025, 9 a.m. That is before Judge Valvo.
Thank you, Your Honor.
Thank you, Your Honor. Sorry.
Bond continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Rodney Carter.
So Public Defender, appearing on behalf of Mr. Carter. Mr. Carter on Zoom. Take that as a no.
Negatory Ghost Rider.
Okay, Judge, we'd ask for an adjournment for the record.
What?
I'd ask for an adjournment for the record.
Oh, Miss Apple's so nice. I almost don't want to do it, you know?
Trying.
But I gotta be fair to everybody. And just as mean. Sometimes that's fairness. Benchmark will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Court does call the case People versus Ronald Sims.
I should call this with people.
Assistant Public Defender Chelsea Virgils, with and on behalf of Ronald. Mr. Sims, please state your name.
Ronald Sims. Thank you. You're requesting an adjournment.
Yes, if possible, could we get the 13th, Your Honor? He has a court date in circuit court on the 18th, was hoping to move this along before then.
So at what point did Virgil think she could ask for what date? Huh? Right now? Oh.
It was
Did
a
somebody
mere
tell her
suggestion.
that? I think Cannon told her to do that.
I'd be a trainer.
And I'm glad she has shed most of what you probably taught her. Of course, I can give you the 13th. We'll adjourn it. Probable cause conference November 13th, 2025, 9 a.m. Bond continued.
Much appreciated. Thank you.
Thank you. See, that's it. She's so nice. So I know she wasn't taught that by Candy. Just saying. Court calls the case, People versus Mia Caruso.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Chairman Dadish, on behalf of Ms. Caruso, who is approaching, can you please say your name for the record? Mia Caruso. Honor. Do you need her to repeat her name?
She said her name.
Okay, I thought you didn't hear it. I thought it was just low. We are gonna.
No, I
this
heard
matter
what
for-
you say. You're old and you can't hear.
Well, you
Is that
usually
what you were saying?
No, that is not what I was saying.
Yes, it is what you're. I'm hurt.
I'm sorry.
Okay, go ahead.
We're gonna be setting this matter for preliminary examination, Your Honor. To our knowledge, all discovery is complete.
All discovery is complete.
To our knowledge, yeah.
People have their witnesses available on the 13th.
I expect we will.
Preliminary examination will be set November 13th, 2025, 2 p.m. That will be before me. And we'll continue. All right. Who's here with her? How old are you, young lady?
You said how old I am?
Yeah.
20.
20. Who's here with you?
My father.
Okay, I thought so. You're all up under him. The daughter would be with her dad when she's scared. Okay, thank you. Court calls the case, People versus Donovan Smith.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Smith. Mr. Smith, state your name for the record, please.
Donovan Smith.
Your Honor, I have two requests. I know. The
I'm only
first,
giving you one.
the first is easy.
Okay, I'll take that one.
We're asking for an adjournment of the PCC. I believe we received the media discovery this morning. Additionally, there's forensics from the state lab that we're waiting on. Who knows how long that's gonna take.
Right.
The second is bond. Mr. Smith would like me to address bond, if I may.
Yes, is he held on anything else or is this?
This is it.
Okay, go ahead.
So Mr. Smith has I believe his bond is currently set at $50,000. He is asking for a reduction, either a personal bond or at least a 10%. He would go home to his mother's home in Detroit. He has no reason for being in Washington County, so he's happy to stay out of the county. He's happy to wear a tether if the court would like to order one. He is not working right now, but he is a caregiver for his grandmother who was ill. She recently had heart surgery, so he does things around the house for her, helps care for her many medical issues. He is planning on going to school in December as well. So given all of that, we are asking the court to consider a personal bond or a reduction.
Response.
Your Honor, the people would object. Mr. Smith currently, according to Lean, has a felony carrying concealed weapon charge that was bound over in Third Circuit Court. He also has a felony unlawful driving away that was bound over in Sixth Circuit Court. And then here in Washtenaw County, he is alleged to have fired a gun at a building. There are numerous shell casings that were recovered from the scene He ran from the scene. He had to be chased down. There was I believe that a canine unit was called and had to find him. And we are waiting for DNA on these shell casings to strengthen this case. So the people would object to a bond reduction and believe it was set appropriately.
So he was on bond or some other type of court proceeding regarding a weapons charge, and then this comes up where it involves the firing of a weapon.
I can't confirm that he was on bond, Your Honor. My record only indicates that matter was bound over in October of 2024. I don't have a resolution of it in third.
Got it.
I don't know if this helps, but he's on HIDA for the in Wayne County for the weapons charge.
So he's up, but he's okay. He's under sentence on a weapons charge and then picks up a case that involves discharge of a weapon at a building. Anything else?
He says he's been compliant with his probation there.
Except maybe the picking up of another charge.
And
particularly a weapons charge.
We do dispute these allegations.
I understand you do.
And he is set for sentencing in Oakland County on that other case on the 6th.
So he's under sentence, or he's about to be sentenced on something else.
Maybe I go there too.
And this offense happened.
Drop down to misdemeanor because it was attempted.
He says it's going to be a HIDA misdemeanor resolution there.
Okay. So actually, Ms. Perrine, you were wrong about something. Both of your requests are very easy. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Sure, I was just being honest, because it's how I am. What'd you say, Cannon?
I said, yes, Your Honor, you're an honest man.
If that's what you said, you wouldn't have had to mumble it. Court calls the case, People versus Edward Castro.
Actually, calls the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Castro.
Edward Castro.
Thank you, sir.
I know you could hear him, Your Honor.
Thank you, Mr. Bukovich. All right, what are we doing?
At this time, Your Honor, I'll be requesting an adjournment. We have begun the referral process for sobriety court up at the circuit court. I have submitted the referral, so Ms. Sample did give me an estimate about 3 weeks to get this interview done, but that is what based upon her time. I know she's down a staff member right now and is training someone new, so it may be a little delayed, but that was the estimate I got from Ms. Sample.
I think that makes sense, Your Honor. He is out of custody, so 4 weeks might be.
So, but she's saying 3 weeks to get it done.
That's from my understanding of the email, Your Honor.
And somehow or another, there's then going to have to be the other part of that process.
Yes.
Mr. Bukovich and I have been in lots of communications. There's no guarantee of felony drug treatment court, but it's something I don't think might be a good choice.
All right, here's what I'll do, because I would normally go to the 20th, but that's your 3 week mark.
Yeah.
And then the next week is actually Thanksgiving.
Yes.
I mean, I'll be here, but probably people don't want to come in. No, I'm kidding. And then it would be that Tuesday, or the Tuesday before, which I just don't think is practical. So what I'm going to do is I'll adjourn this out to December 4th. All right, 2025 at 9. And then we'll see where we are. All right, Mr. Castro, thank you, sir. Bond continue.
Thank you.
Thank you, Your Honor.
Court calls the case, People versus Kevin Smith.
Ashley Feltus for the people.
Anna, on behalf of Mr. Smith.
Your name, sir?
Kevin Smith.
Thank you.
And Your Honor, I have been in negotiation with the prosecutor on this case. A potential resolution would involve him participating in mental health court. So I am going to get him screened to see if that is something that we can do here.
And what's our time frame on that? Do we know?
Do not.
Your Honor, could I have at least 3 weeks? I know we have Veterans Day coming up.
What?
What, Your Honor?
We have Veterans Day coming up?
Yeah, and I.
At what
just- I
point
want-
figure that out?
I celebrate all week. So. Your Honor, we would like at least 3 weeks.
You think, I mean, I don't have a problem putting that out, but.
Well, I'm providing all the paperwork now. I am not sure how long it takes, but,
Why don't we, this is a mental health court, right? So.
yes.
Let's see if we can get him in. I would put it to the 20th, but let's see if we can maybe get an answer. I'm gonna put this on a Tuesday, November 25th, 2025 at 9.
Thank you, Your Honor.
Your Honor, do you want me to address bond? Can we address bond, Your Honor? Your Honor, my client.
Yes.
At the time of this incident, he was just, during this time frame, he was unmedicated. Subsequently, and after this, he is now taking a pill every day. He gets an injection. The crux of his issues definitely stem from mental health needs and homelessness. Since then, his mother has stepped up, and he can live with her. He wants to go and live with her. He could be released on GPS tether. So he's asking that the court allow him to be released to his mother's care.
What city does she live in?
Jackson.
In Jackson?
Yeah.
Response from the people?
Your Honor, I would ask that the court continue the bond as currently set. I think there was at least one failure to appear on this file.
Yeah.
And I would also note that I'm very glad to hear that he's now on an injection and getting the treatment that he needs. So I'm concerned that should we release him without structured mental health court around him, there could be continued failure to appear or.
And what I'm gonna do is, I'm gonna deny your request for a change in bond. I would, after the initial evaluation and screening is done, whatever information can be provided, I'm more than willing to look at it again.
Thank you so much, Your Honor.
So bond, thank you.
I'm gonna come, later today.
All right, there we go.
Oh, my.
Oh, my. Court calls the case, People versus Corey Copeland Nash.
Marshal, please to assist the public defender on behalf of Ms. Copeland Nash. Please state your name for the record.
Corey Copeland Nash.
Thank you, Judge. I have spoken to Ms. Nash and I have reached out to, it was Mr. Bannis who I reached out to on this file. We are trying to get a resolution on this file, but we are not quite there yet. If we could please have a couple of adjournment, hopefully we'll get it resolved.
Probable cause, November 20th, 2025, 9 AM bond continued. All right, thank you. Court calls case of the People versus Derek Stewart.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Stewart is approaching now.
Your name, sir?
Derek Stewart.
Thank you. You're requesting an adjournment.
Yes, Judge, and I did wish to address bond on Mr. Stewart's behalf, but we are requesting an adjournment. I did reach out to the Forensic Center regarding a potential timeline. The email that I received said that still several months.
Competency review, because we don't have a report. They said several months.
The email that I received stated, as a result, we anticipate that it will be several additional months before Mr. Stewart will be admitted for competency restoration.
Well, let me do this. Let me just set it for December 11th. That's about us. We'll see where we are at that point.
The 9th,
The
December.
11th. of
December.
December.
December 11th.
Yeah. All right, Esteban.
Your Honor, based on that correspondence with the forensic center, Mr. Stewart is asking for a release on a personal bond. He has been in custody 154 days. This is the only matter holding him in custody at this time. He reports that he would reside at the Delana Center, and that he is on disability, so he's unable to work at this time. But I understand the severity of the charges. However, they are 4-year felony, been in for several months already, and with the anticipation that this could be an additional several more months until he can get treatment, I'd ask for a tether and for him to be released on a PR bond.
Any response from the people?
Mayor, I think there was previously a time when he had been released on a tether, and then there was a bond violation where he was in possession of a fixed blade knife. Excuse me, I almost said it wrong. I'm just concerned about that. We did give him that chance, and then we had that violation. So I'd ask the court continue to bond as currently set. I'm terribly sorry about the delay of treatment, but
Yeah. What I'm gonna do is I'm gonna deny his motion to change bond at this time. However, what I would indicate is that if, given all of the circumstances, if the people and the prosecutor can come up with some type of structured plan to release him under, then I will certainly take a look at that. It may be difficult with him residing at the Delana, but that I'm looking for something like that. All right, so I'm not saying no, I'm just saying no, give me something else, and
Okay, I will work on that, Judge.
thank you.
Thank you.
Court calls case people versus. Hold on a second. Is it Zakara? Precious, Zakai, Daphne, Persiga. Okay, some of that, there's something I need to be able to leave out. That's like 30 names.
Assistant Public Defender Chelsea Vergils with and on behalf of Zakara Daphne Bursiaga. Please state your name.
Zakara Daphne Bursiaga.
Hold on. I had to do 5, she did 3. Okay, go ahead. So thank you.
Your Honor, we are asking for an adjournment in this case. I think we should be able to resolve it with a plea, just need a little more time.
Probable cause conference November 20th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, Ron.
Thank you.
Court does call the case of the people versus Christopher Thax.
Jonathan Overwater, Assistant Prosecuting Attorney for the People.
Again, Judge. Torshell Feaster, Assistant Public Defender on behalf of Thaxton, who is approaching the podium. Please state your name for the record.
Christopher Thaxton. Thank you, sir.
Thank you, Judge. I did meet with Mr. Thaxton and have had conversations with Mr. Overwater to try and resolve this matter. There are videos in the file that I am reviewing with my client, and he's asked me to go out and look for a few other additional videos. So we're going to kind of do a little bit of investigating, Your Honor. I'd ask for a 3-week adjournment, please, or more.
Will the 13th be enough time for you to get all that done, you think, or?
Yes, it's only one location we need to go.
Okay. Probable cause conference November 13th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. Court calls the case of the people versus David Davis.
And on behalf of Mr. David David, who's approaching. And here.
What?
Yeah, we're gonna elect.
What were you gonna say?
No, I just wanted to let you know we were waiving the exam.
You weren't sure what?
I'm just gonna waive the exam. Okay, were you timing?
I was trying to figure out how long this was gonna take. Yeah. No, go ahead.
That's what I felt it. We're gonna, my client is elected to waive his exam, Your Honor.
Yes, okay. Is that correct, sir?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further proceedings.
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 through 7. This counts 2 through 7 following.
Thank you, Your Honor. At this time, my client will stand mute as to those charges, and we would waive the formal reading of the information.
Defendant having waived formal reading, standing mute, court will enter not guilty plea as to all 7 charges. Pretrial in this matter will be set for
December 22nd at 1:30 with Judge Simpson.
December 22nd, 2025, 1:30 before Judge Hammoud.
Thank you, Your Honor.
Bond will continue. Thank you, sir. Court does call the case of the people versus Andrew Travis.
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
Assistant Public Defender Natalie Pate, with and on behalf of Mr. Travis, who stands to my right, please state your name for the record, sir.
Andrew Jacob Travis.
Thank you.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. I'm requesting a very brief adjournment. The prosecutor is on board with my proposed resolution as of last night, and during the beginning part of the docket, he did submit to me the plea form, but I do need to go over that with my client further. My client is being held on a Wayne County matter. I will say for the record as well.
Adjourn the matter to November 6th, 2025, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Denali. Is it Deloach?
Correct, Your Honor.
Ally's on behalf of the people, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Deloach. Mr. Deloach, can you please state your name for the record?
Dinali Deloach.
Dinali
Deloach.
I will never remember that.
That's the most unique name you probably ever.
Yeah.
And Your Honor, we are just
I
asking
was
this.
just doing something today. I told you.
I know.
I said I saw his name on some cases. Go ahead.
Your Honor, we're just asking to set this matter for a preliminary examination with regard to discovery. We are only missing a 911 call. I've reached out for that. It's not pertinent for purposes of running the prelim.
All right, so except for 911. People have their witnesses available on the, well, he's out, so the 13th.
We'll do our best, Your Honor.
All right. Preliminary examination will be set the 13th, November 13th, 2025, 10 a.m. That's before Judge Barr.
Thank you, Your Honor, and we will continue working towards a resolution in the interim.
Thank you very much, Justice.
So that I just, because I just want to make sure, I'm trying to keep it structured. Court does call the case, people versus Jonathan Watts.
Ally's on behalf of the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Watts. Mr. Watts, state your name for the record, please.
Jonathan Allen Watts.
Thank you.
You know, we're asking for an exam, please.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available on the 10th.
We'll do our best, Your Honor.
All right. Preliminary examination in person will be set November 10th, 2025, 9 a.m. That is before Judge Valvo.
Thank you.
Thank you. Bond continue. Court does call the case, people versus Benjamin Detlefs.
People offenders.
Oh, there he is.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Detlefs in both matters. He's approaching judge. State your name, Mr. Detlefs. Benjamin Detlefs, right?
All right. I have 2 misdemeanor resolutions in the case ending in 5228. defendant will be pleading no contest to 2 charges of attempted resisting and obstructing a police officer, the 1-year offenses. Those are constituting counts 3 and 4. Upon a successful no contest plea of those charges, counts 1 and 2 would be dismissed. In the other matter, ending in 0057, the defendant would be pleading no contest to attempted resisting and obstructing the 1-year offense, with count 1 being dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor.
That is correct, Judge. There's no sentencing agreement or no request for a COBS in this matter. I will note Mr. Detlef did spend considerable amount of time incarcerated.
All right. May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
So do, Your Honor.
State your
All
name.
right.
Benjamin David Detlef.
Thank you. Sir, it is this court's understanding that in 2 separate cases, you'll be pleading no contest to the charge of attempted resisting and obstructing a police officer. 3 counts of that. You understand that?
Yes, I do.
All right. Those are misdemeanors, punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, I do.
Okay, let me explain 2 things about it just to make sure you understand. First thing you need to understand is it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
You understand also that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, I do.
All right. And you understand, sir, that in the case ending in 5228, that's being the events that occurred in the city of Ann Arbor, that I would, while I'm taking your plea, I would not be your sentencing judge, and that you would be sentenced before Judge Valvo in the 15th District Court. You understand that, sir?
Yeah, okay, yes, yes, Your Honor.
I'm sorry, you do?
Yeah.
Okay. Understanding all of that, do you still wish to plead no contest?
Yes, I do, Your Honor.
All right. Starting again in the city of Ann Arbor case ending in 5228, to the charge of resisting and obstructing as contained in count 3, how do you plead?
No contest, Your Honor.
To that same charge as contained in count 4, how do you plead?
No contest.
Going over now to case 0057, to that charge of attempted resisting and obstructing, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, I do, Your Honor.
You signed advice of rights forms in these cases?
Yes, I have.
Pardon?
Yes, I have.
Okay. Any questions regarding any of those rights?
No, Your Honor.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes, I do, Your Honor.
All right. Are you on probation or parole?
No, Your Honor, I'm not.
Has anybody promised you anything other than what's been stated here today on the record to you to plead? Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes, I am.
of your own free will.
Yes, I am, Your Honor.
All right. In the case ending in 5228, the court has been provided and has reviewed Ann Arbor Police Department report for their case number 24428. And also in the other matter, Pittsfield Township Department of Public Safety report for their, Washtenaw County prosecutors, Washtenaw County Sheriff's Office report for their case number 2475598. Any objection to the court having reviewed either of those reports?
No, Your Honor, thank you.
No, Judge.
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, if I accept your plea or accepting your plea, if between the time of my acceptance of your plea and the time of sentencing, commit misconduct as defined under the Michigan court rules, The court would no longer be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, I do, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Judge.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Judge.
In case ending in 528, court will accept the defendant's pleas of no contest to counts 3 and 4. Counts 1 and 2 are dismissed, and I'll just finish with that matter. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
November 18th at 9 a.m.
November 18th, 2025, 9 a.m. before Judge Balvo. Bond on that matter will continue. Other matter, court will accept the defendant's plea to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
December 10th at 9 a.m.
December 10th, 2025, 9 a.m. That's before me. Okay.
Thank you, Your Honor.
Bond in that case. And Mr. Detlef, what you may want to do, just to get the process started for us, is on your left, on your way out is my probation department. Stop in there and just check it.
Okay.
Okay? Thank you.
This is 15th. Call them, okay? Okay. All right.
Court
Thank you,
does
Judge.
call the case, People versus Christopher Whitaker.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Jay Bellinger on behalf of Mr. Whitaker, who approaches. And can you state your name for the record?
Christopher Whitaker.
And Your Honor, I have submitted a mitigation to the prosecution. I'm just waiting to hear back. So we're just asking for a brief adjournment.
That is correct, Your Honor. I received that yesterday. Unfortunately, I was waylaid and did not have the opportunity to review it. I will review that as soon as possible.
November 13th, 2025, 9 a.m. Bound.
Thank you, Your Honor.
Thank you.
That's the last until we get to the. Court does call the case, People versus Sean Douglas.
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Mr. Sean Douglas.
Good afternoon, Your Honor. Sean Douglas.
Thank you.
Judge, the court should be in receipt of a referral to mental health treatment court. Mr. Douglas had been referred previously to mental health treatment court. Unfortunately, last time we were here, we were hoping he'd be able to get over there to his appointment, which was scheduled that same day. There were 2 appointments that we were not able to get him to do the intake.
So he was not accepted because of the.
He did not complete the intake, correct. It wasn't a denial, it was just so hopefully we'll get it done this time around, Judge.
Okay, and that was mental health. Okay, let's do it this way. Probable cause conference, December 4th.
Okay.
2025, 9 a.m. Let's see if we can get an answer or something.
Absolutely.
All right.
Thank you so much.
Thank you, Your Honor. Thank you. Court calls case, People versus Thomas Lee Ellis.
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Mr. Thomas Ellis, who's approaching. Mr. Ellis, state your name for the record.
Thomas Ellis.
Judge, we'd like to set this matter for preliminary examination, please.
Discovery is complete.
To our knowledge, Your Honor, yes.
And people have their witnesses available the 10th.
We can charge it as Your Honor.
All right. Preliminary examination in person, November 10th, 2025, 9 a.m. That is before Judge Balvo.
Thank you, Judge.
Thank you. Wow, don't do that. Okay. I mean, bless you.
Where's this guy?
Here.
That was scary. Clerk calls the case, People versus Robin Finney.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Finney. State your name for the record, please.
Yes, Robin Finney.
Thank you.
Ms. Finney is appearing from Bear River. We are asking for an adjournment because her completing Bear River will affect the resolution that happens here.
How much more time?
She completes Bear River on November 19th.
Okay.
So I suppose I'd ask for a date after then if possible.
Really? After the 19th?
Yeah.
That would make, that would make sense, wouldn't it?
It would.
If everything's contingent upon that.
It would. I mean, I could come here and ask for an adjournment again, but it depends on what the court wants, what the court wants, I'm happy with.
All right. Here's what I'll do. I'll adjourn this out to, why don't we go to December 4th? We'll make it through the holidays there. All right. Okay, Miss Finney, how's it going up there for you?
It's going great, Your Honor. It's really going good for me.
Pardon?
I said it's going great, Your Honor.
All right, fantastic. That's good to hear.
Thank you for asking. I'm learning a lot. I'm actually paying attention this time.
And you're paying attention this time, right?
Yes, Your Honor.
That's good. Okay, I will adjourn this then out to December 4th, 2025, 9 a.m. Bond will continue. All right.
Thank you, Your Honor.
Thank you.
Continued good luck to you. Okay?
Thank you.
Court does call the case, People versus Megan Gibbs.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Veronica Glenn, I would like to request permission to practice pursuant to Michigan Court Rule 8.120.
She just
Under
snuck
the-
up. Did you notice that? She just, I didn't expect anybody. Now she just snuck up. I'm sorry. Go ahead.
That's okay. Do you want me to start over?
Yes.
Okay. Veronica Glenn, I would like to request permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Is she really your supervisor?
Yes.
Is she? Is she any good?
She is. She's great.
Is she?
Yes.
You know nothing though. So of course anybody's gonna look great. All right. We have a problem here. Ms. Gibbs, could you state your name?
Yes, good morning, Your Honor. Megan Gibbs.
And where is she?
I'm in Naples, Florida, Your Honor.
Okay. I'm presuming you've seen the bond violation report, counsel.
Yes.
And I had already issued, didn't I?
Yes, exactly.
She needs to get to Michigan.
Yes, we are asking for an adjournment on behalf of Ms. Gibbs in order for her to have time to appear in person.
Well, she needs to do it soon because there is already a warrant out for her arrest. How much time is it going to take her to get here?
Ms.
Your
Gibbs, how much
Honor-
time?
Oh, I apologize, sorry.
Go
ahead. Oh, I was just
Miss-
saying, I just had an interview on Tuesday for a new job because I have been laid off. So I'm probably going to be starting next week or the following. It's gonna be a 2-year project. I am an electrician. So, as soon as I get back to work, I would assume maybe a month.
Well, I don't, know that it works that way, Miss Gibbs. Because either you can give me a reasonable time at which you're gonna be here, or we're gonna come and get you.
Okay, I just don't have the money to do it.
Well, you had the money to
but-
drink.
Yes, I did, Your Honor. I'm not making any excuses for that. I did, but I was being physically abused and I was in fear of my life at the moment. And my possessions were stolen from me, from my
Why
friend.
don't we stop for a moment?
Okay, okay. I apologize.
Here's what I'm gonna
Would-
do. I'll give her that time period. I'm gonna set December 4th. But she needs to be here in person. Probable
Yes,
cause
Your Honor.
conference will be adjourned to December 4th, 2025, 9 AM. That is in person.
December 4th, Your Honor.
Your Honor, is the court
Yes.
aware of Ms. Gibbs' BAC at the time of her arrest on this matter?
Am I aware of it?
Because it was a .348, so the people have
Yeah.
serious concerns about her safety if she's not testing.
Right, and I understand that, and I mean, quite frankly, so I've given that date, if that doesn't, maybe meet with the people's concerns, they certainly, there's a valid warrant, with extradition, so they can go get her. You guys can go get her if that's what you want. I'm gonna give her time to get here, but, okay?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Edward Gross. Why did
Water
she send
Assistant
her up
Prosecuting
there
Attorney
with
for
the
the
hard
People.
case? You, why,
Assistant Public Defender Chelsea Ridgefield.
why, no, I'm not talking, that was so mean to do to her. That was.
Edward Gross.
No, that was great supervision. No, that was great. That was great the way you did that, Cannon. Leaving that poor child out there to try to deal with a warrant from Florida. Go ahead, sir. Sir, what is your name?
Edward Gross.
Thank you. And you're requesting an adjournment on this?
Yes, we are, Your Honor.
Probable cause conference, I'll adjourn it to November 20th. 2025, 9 AM. All right?
2025.
Yeah, this year.
Thank you, Your Honor.
It's been that way all this year.
I know.
Bound will continue. Well, it has. Well, you look at me like I was just trying to help. Court calls the case, People versus Evan Sherbert. Sherbert. Sherbert would be actually.
I believe so, yeah.
For the people.
Camera Dadush on behalf of Mr. Sherbet. Mr. Sherbet, can you please say your name for the record?
Evan Sherbet.
Thank you, sir. All right, what are we doing?
We're just asking for an adjournment, Your Honor. We just got contact information, but yesterday.
Oh, okay, you just got, okay.
We would have had this resolved.
Probable cause conference, sir, I'm gonna adjourn this out to November 20th, 2025, 9 AM. All right?
Okay, thank you, Your Honor.
Hold on a second, sir. What?
Yeah.
I was just confirming, we had it used in the Livingston County jail, so I will cancel the writ.
He doesn't look like he's in jail.
No, he got released, I believe, the 15th, right?
Yes.
Oh, okay, all right, so his bond will continue. All right, sir?
All right.
Make
thank
sure
you.
to keep in contact with your attorneys, okay?
Absolutely.
All right, thank you.
Thank you.
Court calls case, People versus Kimberly Stampley.
She is not present, Your Honor. But
So.
this one is good.
Tranter on behalf of the state of Ohio. We are here for sentencing. Has everyone reviewed the PSI?
Yes, Your
Ms. Tranter, anything on behalf of the state?
Nothing further, sir.
Anything from probation?
Nothing further, Your Honor.
Mr. Collins?
Nothing, Your Honor. We discussed this matter in chambers. We'd rest on that. I also would, but I would point out, I did file a sentencing memorandum.
I reviewed it.
Okay, that's all I was looking to do. And again, I would highlight what we discussed in chambers. Mr. Homer, and you'll probably hear directly from him himself, is extremely remorseful. I know alcohol is not an excuse, and he understands that too. He prior, even while cloaked in the presumption of innocence, he went ahead and enrolled himself in recovery works. He's been in recovery work since the day of this offense. He just told me here that even when it ends, they have an aftercare program. He's considering that one. His church group has been working with him too, as a program of aftercare. He's the father of an 8-year-old, sole provider of an 8-year-old that he has. Again, he's extremely remorseful, not making excuses, just was alcohol that woke him up, didn't know where he was at. For about a minute there, he was acting like an idiot. He accepts responsibility for that.
Okay. Mr. Olmer, is there anything you'd like to say before I sentence you?
Yeah, I'd just like to apologize for my actions, and I know personally it's not going to happen again.
All right, the court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court does find that you are amenable to community control, so I'm going to place you in community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, or marijuana. There's no THC use permitted in any form. You are ordered to continue the treatment that you have started to its successful conclusion. You're ordered to complete do the corrective thinking course. Now, you're also subject to a discretionary period of post-release control, which means that if you are sent to prison on discharge upon your release, the adult parole authority may supervise you for up to 2 years. If you violate their supervision, they can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. The court does find that you have the present and future ability to pay the cost of prosecution, so while I'm not going to fine you, there's no restitution requested. You are assessed the cost of this prosecution. You do have a right to appeal the court's decision if you're sentenced to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Tranter, is there anything else?
No, sir.
Mr. Collins?
Nothing, Your Honor.
All right, good luck to you, sir.
Thank you, Your Honor.
What is that? Seriously?
This is case number 25CR42851, the State of Ohio versus Tiffany Corbett. Ms. Corbett is before the court with her counsel, Mr. Elter, Ms. Nicholson, on behalf of the State of Ohio. Ms. Corbett, your attorney had filed a motion for intervention in lieu of conviction, so in a moment you will be asked to change your plea to guilty of the felony charge of receiving stolen property. The court accepts your plea but does not make a finding of guilt. Instead, I'll hold your plea in abeyance or set it aside and require you to complete a plan of intervention. If you successfully complete that plan of intervention, then the prosecution of this charge will end with no finding of guilt, and I will dismiss this charge against you. Do you understand that?
Yes, sir.
The other side of it is, if you fail to complete the plan of intervention, if you continue to use illegal drugs or you break the law, the court will be able to make a finding of guilty that's based on your plea today, and then I'm going to sentence you on this felony charge. Do you understand that?
Yes, sir.
How old are you?
I'm 32.
How far did you go in school?
I graduated high school.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you if you fail to complete ILC?
Yes. I mean, no, sorry.
I mean, I know Mr. Elter, I'm
Yeah.
sure he did not, but does anybody promise you anything?
No, they didn't promise me anything. They
Does
just
anyone
told me that-
did anyone threaten you in any way to get you to plead guilty against your will?
No, sir.
Are
Sorry.
you satisfied with the representation you've received from Mr. Elter?
Yes.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document. It's called a change of plea and entry. On the second page on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of receiving stolen property as a felony of the 4th degree that carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
You're also subject to a discretionary period of post-release control, which means if you are sent to prison on discharge, upon your release, the adult parole authority may supervise you for up to two years. If you violate that supervision, you can be returned to prison by the adult parole authority for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional sentence that you receive. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, or what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the state. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you want to proceed.
Yes.
Your Honor, if this would have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about July 7th, 2025, in Deerfield Township, Warren County, Ohio, the defendant was stopped operating a 2022 motorcycle that did not have a visible license plate. That motorcycle was reported stolen from Brown County on March 1st of 2025.
Mr. Elter, anything on those facts?
No, Your Honor.
Ms. Corbett, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge what she said is true?
Yes.
I'm a little bit concerned because when you were asked about this, you said, you answered, "I'm very upset about the current trouble I'm in because I'm being accused, I didn't do. What of being accused I didn't do?" When asked if she thought there was a victim in the offense, she answered, I'm unsure if there's any victim. I didn't know it was stolen." That's the same thing that you told the officers at the scene when you were arrested. However, it became later through some conversations with this other person that was at the scene that you were trying to pull a fast one on the officer, trying to talk your way out of it. Now, which is it? Did you know it was stolen?
No, I did not, sir. No, I did not. I purchased the motorcycle, not knowing.
You
it
ever
was
produced a
stolen.
bill of sale for it?
No, I was waiting on him to get me the title, because he said that he was going through something with his wife and he needed to get rid of the motorcycle, and so.
Who'd you buy it from?
It was a friend of mine.
The guy that was there at the scene that night?
No, that guy, I was coming home from work when I got pulled over, and the guy that was with me works with me. So, yeah. He was just following me home. He lives in the same area as I do. I was going home to my house and he was going to his house. We were getting off of work. And I do have documentation of me being at work and clocking in at work and then getting off at that time and leaving from work and then going home.
But you've never produced a bill of sale for this motorcycle?
No, sir. I was waiting on him to get me the title and the bill of sale, and then he just dropped off the face of the earth. I haven't been able to find him since.
So do you think a reasonable person would understand and believe that the motorcycle was stolen?
I didn't think about it twice because of him being my
Well,
friend.
think back on it now. Do you think
Yes.
a reasonable person would believe that that motorcycle was in fact stolen?
I should have thought about it, yes, sir.
And again, you understand all the rights you're giving up, entering a plea of guilty, those rights we discussed.
Yes, sir.
What is your plea?
My plea is guilty.
All right, the court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights we discussed. I will accept your plea of guilty. I am going to grant your motion for intervention in lieu of conviction and order these proceedings stayed pending the completion of that terms of that supervision. So you'll be on aisle C for up to 3 years. You'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, and there's no marijuana permitted, no THC in any form. Do you understand?
Yes, sir.
The recommendation for your treatment is an intensive outpatient services, which I'm going to order both for mental health and substance use disorder treatment. You are to complete that. You are to engage and complete that immediately. You are also ordered to complete the Thinking for a Change course.
Okay.
Looks like you have 19 days jail time credit. All right. Ms. Nicholson, is there anything else?
No, Your Honor.
Mr. Alter?
No, thank you, Your Honor.
All right, let's get this right. Okay?
Thank you, Your Honor.
Have a good day.
This is case number 25CR42609, the State of Ohio versus Dean Ward. Mr. Ward is before the court with his counsel, Mr. Elter, Ms. Ms. Hyatt, on behalf of the State of Ohio.
Really confusing.
I had a
Really confusing.
33 1/3% chance of getting that right, or 67% chance of getting it wrong.
That's okay.
I can always look at my docket and it said Ms. Hyatt. Ms. Hyatt, what are we doing?
Yeah, my understanding, I believe, is that the defendant's gonna withdraw his prior plea of not guilty, and her plea of guilty is charged to the one count of theft at 5.
All right, Mr. Elter, is that accurate?
That is correct, Your Honor. You should have a plea form there.
I do. Okay, Mr. Ward, you're telling me you're going to change your plea to guilty to the one count of the indictment before we get to your change of plea. I am required to go over some things with you, okay, sir?
Yes, sir.
How old are you?
24,
How far did you go in school?
11th grade.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Elter?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document, this is called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of theft as a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
You're also subject to a discretionary period of post-release control, which means if you are sent to prison on this charge, upon your release, the adult parole authority may choose to supervise you for up to 2 years. If you violate their rules of supervision, they can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes.
Now, you are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you with the help of Mr. Elter, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes.
Do you believe you understand each of these rights we've discussed?
Yes.
Do you understand that when you enter plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you want to proceed.
Yes, sir.
Ms. Hyatt?
Your Honor, if this case had proceeded to trial, the state would have shown beyond a reasonable doubt that on 2 occasions between December 13th and December 16th of 2024, while this defendant, Dean Ward, was at the Best Buy in Deerfield Township, Warren County, Ohio, he did with purpose to deprive the Best Buy of property. In this case, it was computers. He did knowingly obtain and exerted control over the property along with one of his co-defendants, Mr. Johnson, without the consent of Best Buy. It is a felony of the 5th degree due to the fact that the computers that they both stole on those 2 occasions came to $4,999.96.
Mr. Elter, anything on those facts?
No, Your Honor.
Mr. Ward, did you hear the statement that she read?
Yes.
Do you admit and acknowledge what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we just discussed?
Yes, sir.
What's your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty. Based upon the statement of facts in your plea, the court will make a finding of guilty. Now, sir, I'm going to go ahead and order a pre-sentence investigation. We'll come back in a few weeks, and we'll do sentencing at that time, okay? Stay in contact with your attorney. You need to check back in with court services. Did you already check in down there?
Did you go to pretrial?
Did he
Yeah,
test?
he did.
Was he negative, Judge?
He was.
Thank you.
All right, so go back down there. You need to check in just to schedule your interviews, okay, sir?
Okay.
You have any questions?
No, sir.
Okay, stay in touch with your attorney.
Did you need to see the pictures from both of them?
Hang on one second.
Sorry.
Shoot, I just got out of that.
Apologize.
Ty, do you have a position?
I guess my question, I was just trying to see why we had the ankle monitor on.
Yeah,
Was
I'm
it
not
because
sure
we were
either.
having issues with finding him?
He's not, I've not had any issues with him.
He did not have, when he was in jail originally, Your Honor, he did not have an address that he could be released to, so they put the GPS on him. His mother's here with him today.
Case manager.
Oh, case
Case
manager,
manager.
sorry. Case manager, he is actually in,
A little different.
you're in a program right now.
You're in like a sober living? Is this what's he in?
No, sir. He is at Hope House, homeless shelter in
Oh,
Middletown,
Okay, yeah.
participating in treatment.
And you don't need to monitor on him. They tell me he's been compliant while he's been on a monitor. Is that your
Yes, sir.
experience as well? Okay, I will go ahead and order the monitor removed today, okay?
Thank you, Your Honor.
Just continue to follow through with the program, okay, sir?
Okay.
Okay, good. Thank you.
Thank you.
Okay. Did you see, I filed the memo in opposition.
Name.
On it for the record. My name is Dwight Miller. I'm American State National. I'm here to challenge jurisdiction. I'm here on special appearance to establish jurisdiction, bro.
Can we approach, Your Honor?
Your Honor, I need to challenge jurisdiction.
Okay, how are you intending on doing that?
Well, Your Honor, can you show me your how I'm supposed to do this? See, it's certain things I can't remember because y'all got me in here and I don't have access to the law books. But it's okay.
Are there certain things you want me to show
your
you?
delegation of power, sir?
Pardon?
Can you show me your delegation of power and your oath of
My
office?
delegation of power.
Yeah,
It came from the people of Washington County that elected me. I have a certification of election in back. You want it?
Mr. Miller, as your
I would like
attorney,
a
I
copy of your surety bond,
advise-
please, and your oath of office.
My surety bond. I don't
Yes.
have one. I'm insured by the county.
So you don't have one?
And
Okay. You don't have a surety bond, huh? So what's your oath? You do
Mr.
have
Miller,
an
I'd
oath.
advise
You
not
do
to-
swear oath to the Constitution, right? Yes or no?
I'd advise you not to continue this line.
Man, I'm in here. I done got victimized this morning. Are you serious? Can I get a breakout room with my attorney or my so-called attorney?
So-called attorney? No, he's a very good attorney, and he's not a so-called attorney, and you'll not refer to him that way because as you won't be disrespected, neither will he.
Okay, may I speak with the attorney in a breakout
You
room?
can do that on your own time. He doesn't get a breakout room here because he's live in the courtroom.
Okay. So
what are we doing with his case now that my jurisdiction has been established?
Okay, I'm putting the motion in for dismissal. Because ain't no so-called
Motion for
witness or
dismiss is
victim to
denied.
sign a
What are we
sworn
doing?
affidavit against me.
Please approach, Your Honor.
And not end this? Yeah, oh. Of course, yes, you may.
So how's y'all having a conversation without me being there?
Gonna do it in. Okay, we're back to the record in the Dwight Miller case. What I'm gonna do, Counsel, you're requesting an adjournment in this matter.
I am, Your Honor. Upon information, believe there may be a new case coming. I understand Mr. Miller booked into the
Your
jail
Honor.
at 10 this morning.
Your Honor.
So I asked you one
I
day to
object.
evaluate.
I object anything she talking about. First and foremost, how is you testifying?
That what?
First and foremost, Your Honor, I want this charge dismissed, man. At no time given, the lady
I
lied.
know, I heard your motion to dismiss. I
Okay,
denied
listen.
it already.
Okay, listen, Your Honor, under the Constitution, what is it exactly? The maximums of law, if something comes from a falsehood, what is that? The first words out this woman's mouth, she lied. She made a story up talking about somebody
Okay,
pulled a
this
weapon at her.
woman is an
Nobody pulled no
assistant
weapon at her because
prosecutor.
nobody
first
had
of
no
all.
weapon.
I believe he's speaking of the complaining witness, but,
Oh, the complaining witness. Oh,
But-
not Ms.
but
Felton?
Mr. Miller, I would advise you not to say anything more. Given the circumstances, it may be prudent to discuss this matter further and to see, there's a couple other things pending, as well as a potential new charge they're indicating. This might be something we want to set
No.
over for a week.
No. I'm not worried about no new lies. Look at me. I got beat up this morning, bro. I called Pittsfield police 13 times. I was getting assaulted with motherfucking tasers and shit.
Okay.
I put it on the record. Then all of a sudden they want to switch it up to make it seem like I'm threatening somebody. I ain't threatening no one.
Okay, but we can't resolve
I
all
never
that today.
threatened no one. The same people that's
know.
making these statements, they all three on felony probation. They done got caught. Their house just
Okay,
got
so we
raided.
can't
And
resolve
then they up
that
here
today.
playing line up on me.
Okay, so look, we can't resolve that today. And I think the best thing to, so that everybody can try to figure out what's going on, is I'm going to adjourn it out a week. Rather than 2 weeks. I'll try to expedite it. Let's see if we can get to the bottom of it all. So,
Your
probable cause conference.
Your Honor.
Probable cause conference will be adjourned to November 6th, 2025, 9 a.m. Bond will continue.
And I should correct my statement, that MAG thing we saw, we discussed at the event, I think it's just the court is going to. I don't know that it's revolving the court. Okay.
Thank you.
So I just got railroaded, huh?
No, that's not railroaded.
Yeah,
I'll let you know when that
because I'm not consenting to none of this. The lady,
Yeah, cut him. I'm done. I'm so done. Is he gone? I feel a cold coming on for this sick. It's like a hairball. I don't know. Court does call the case. The people versus Alexis Chapman.
Your Honor.
Kenneth Overwater,
Your Honor,
Assistant
David-
Prosecuting Attorney for the People.
David Rudoy on behalf of Alexis Chapman, who's present and making her way to the podium now. Today is the day and time set for probable cause conference in this matter.
And you're looking for an adjournment?
That is correct, Your Honor. I would request 30 days. I do believe there is going to be some voluminous discovery in this matter. And I was just retained this morning.
Any objection?
No, Your Honor.
Probable cause conference, December 4th, 2025, 9 a.m. Bye. Thank you.
Your Honor, I apologize. I have a trial scheduled that day.
Said 30 days.
I'm sorry, I was bad at, Your Honor. Could I get one extra?
The 11th.
Thank you so much.
Will that work?
That is
You
fantastic.
sure you don't have a trial?
I'm
Or you
positive.
need to check?
I
Shouldn't have gone after that guy.
I brought my surety bond, Your Honor. Thank you very much, Your Honor.
All right, thank you. You know, sometimes it's better to start out that way because then everybody else looks good. Court does call the case, People versus Stacy Lincoln.
Trevor Mazel for the People, Your Honor. Good afternoon.
Good afternoon. Yeah, where have you been?
Working. Elsewhere. The office.
With another court? Another judge? Was it a felony? What were you doing? Never mind. We'll talk later. All right.
David I. Goldstein, appearing on behalf of the defendant. State your name, sir.
Stacy Lincoln.
Thank you.
Judge, when Patrick Conlon Senior was on the bench, we always wanted to go after he sent some guy to prison.
Exactly, exactly. I feel bad for all of these people here. No.
We need an exam date, Your Honor.
You need an exam date, all right. All discovery is complete.
I believe so, Your Honor.
All right.
Discovery is complete, Your Honor.
This
Yes.
is where it's gonna get complicated. I thought it was gonna be bad with kilowatts. So, the week that I'm setting these, I have that Monday, the 10th, or I have the 13th. There are 2 times on the 13th, because yes, I do preliminary exams.
Your Honor, Monday, the 10th would work. I have a trial scheduled right now, but I'm going to Judge Slays where I think that case is going to plead out. So Monday, the 10th would work.
That will work? Oh, okay. It was better than it with kilowatt. People would have their witnesses available that day.
Yes, Your Honor.
Preliminary examination in person will be set November 10th, 2025, 9 a.m. That is before Judge Balbo.
Thank you, Your Honor.
Thank you. Bound. Thank you, sir. Court calls the case, People versus Dejon Lewis.
Governor may vote for the people, Your Honor.
Good afternoon, Judge Christopher Quinn, appearing on behalf of Mr. Lewis.
Your name, sir?
John Lewis.
Thank you.
We are requesting another PCC date, Judge, discovery reasons.
You're doing what?
For discovery reasons, we need another PCC.
Are you asking me to adjourn this?
Yes.
You have a green sheet? No.
No.
I know, it's just like you showed up. Okay. I need a green sheet. I'll adjourn this out. I'll adjourn it out to November 20th to, oh no, you want the 13th.
There we go, Judge. I must be making,
So you want the 13th, you don't have a green sheet ready,
I'm making,
and I should just do that for you.
no, I'm sure you do it for other people as well.
No, I would, I absolutely would not.
I'm just trying.
They would not be so presumptuous to even ask, but that's all right. You already did. November 13th, 2025, 9 a.m. bond continued.
Thank you, Judge.
I'll expect the green sheet so I can sign off. Court calls the case, People versus Milton Ray.
However, on behalf of Mr. Ray, who is approaching the podium and will be standing to my right. Mr. Ray, once you get up here, please introduce yourself to the court.
How you doing there? Milton Ray?
Very good. Thank you for asking.
Your Honor, I was just appointed recently, so we are asking for an adjournment for discovery in this matter.
November 20th, 2025, 9 a.m. bond continued.
Perfect. Thank you, Judge.
I know, I said it.
Thank you, Judge.
Thank you, sir. Court calls the case, People versus Samuel Freeman.
Jonathan Overwater, Assistant Prosecuting Attorney for the People.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Freeman. Mr. Freeman, can you please state your name for the record?
Yes, Samuel Freeman.
Okay, thank you.
Are we doing the plea form?
We are, Your Honor.
All right, I have before me a plea form that indicates that the defendant will be pleading guilty, or no contest, excuse me, charge of possession of a firearm on certain premises.
That's correct. That's a 90-day misdemeanor, Your Honor.
90-day offense. On a successful plea to that charge, counts 1 through 3 will be dismissed. That's the court's full understanding of the agreement.
That's our understanding as well, Your Honor. And I would ask at the end of this for your consideration for immediate sentencing. I did talk to Mr. Overwater about that. He had no objection, but we. Okay. Thank you.
That can happen.
Okay.
So at what point, people have been asking me for stuff all day.
I haven't asked you for anything today so far.
But I'm wondering why you joined on the bandwagon. We'll talk later. Mr. Freeman, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, state your name again, please, sir.
Yes, Samuel Freeman.
All right, sir, it is this court's understanding that you are going to be pleading no contest to a charge of possession of a firearm on certain premises. That is a misdemeanor punishable by up to 90 days, a $100 fine plus court cost. Is it forfeiture of the device also, or weapon?
I didn't read that it was a mandatory forfeiture, Your Honor. I didn't see that. I just saw 90-day and or $100.
Okay. This offense may also require that there be mandatory forfeiture of the weapon or device. You understand that, sir?
I do.
All right. Do you understand what a no contest plea is?
I do have a full understanding, yes.
All right. Two things I have to make sure that you understand. It first of all means that you're not further desirous or wanting to contest this charge. You understand that?
I do understand.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I do understand.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, I understand.
All right. Basis for the no contest plea.
Fear of potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
I did, yes.
Any question regarding any of those rights?
No.
You understand that you're giving up all of those rights, including the rights contained under paragraph 5, which are your trial rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been, bless you. Court has been provided and has reviewed Ypsilanti Police Department report for their case number 258978. Any objection to the court having reviewed that report?
No objection, Your Honor.
No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if I accept your plea and you commit misconduct as defined by the Michigan court rules between the time of this plea and the time of your sentencing, any sentence recommendation or evaluation the court would no longer be bound by, and you would not be able to set aside your plea. You understand that, sir?
Oh, I think he froze there.
Mr.
276325CR42925, the State of Ohio versus Kevondre Walton. Mr. Walton is before the court with his counsel, Mr. Guyman, Ms. Tranter, on behalf of the State of Ohio. Ms. Tranter.
Your Honor, it's my understanding that Mr. Walton is prepared to change his plea on both cases this afternoon to guilty as charged. We're going to have an agreed recommended sentence. Well, I'm sorry, on the let's see, what number is that? The illegal conveyance. He's going to plead guilty to count 1. State will ask for a dismissal of counts 2 and 3 in exchange for that. On that particular number, we're going to have an agreed recommended sentence to propose to the court of 9 months. On the remaining case, which is the 925, that is an F5, we're going to have an agreed recommended sentence of 6 months, both to run consecutive to each other and consecutive to Mr. Walton's current time, for a total of 15 months.
Mr. Guyman, is that accurate?
Yes, Judge.
All right, Mr. Walton, you're telling me you're going to change your plea to 1 count from each indictment. Before we get to your change of plea, I am required to go over some things with you, okay, sir?
Yes, sir.
How old are you?
24.
How far did you go in school?
11th grade.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Yes? Has anyone promised you how the court would sentence you other than this recommendation that's being made to me?
15 months total.
Has anybody promised you anything other than this recommendation?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation you've received from Mr. Guyman?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me two sets of documents, and we'll go over these one at a time. But under case number 42763, on page 2 of this change of plea document, there's a signature on the line marked defendant. Did you sign this?
Yes, sir.
Did you read it and go over it with your attorney?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of illegal conveyance of drugs into a detention facility as a felony of the 3rd degree. That carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. Do you understand the maximum penalty?
Yes, sir.
Under case number 42925, again on the second page of this document, on the line marked defendant, there is a signature. Did you sign this document?
Yes, sir.
And did you read this and go over it with Mr. Guyman?
Yes, sir.
And you believe you understand what this document says?
Yes, sir.
This document says you're entering a plea of guilty to one count of aggravated possession of drugs as a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. Do you understand the maximum penalties on this?
Yes, sir.
Now, both of these cases, you are subject to a discretionary period of post-release control, which means that upon your release from prison on these charges, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison by the adult parole authority for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you with the help of Mr. Guyman, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictments. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you will be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you wish to proceed?
Yeah.
All right.
Your Honor, regarding case number ending in 763, illegal conveyance count 1 occurred on March 27th, 2024. Warren County, State of Ohio. Defendant at that time was an inmate at the Lebanon Correctional Institution. He did receive from a visitor a chapstick containing 40 Suboxone strips, which he conveyed into the prison. As to case ending in 925, aggravated possession of drugs that occurred on February the 2nd of 2025 at Lebanon Correctional Institution. After a strip search, defendant was found to be in possession of paper laced with 5-fluoro-ADB, a Schedule 1 controlled substance.
Mr. Guyman, anything on those facts?
No, Your Honor.
Mr. Walton, did you hear the statements that she read?
Yes, sir.
Do you admit and acknowledge what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed?
Yes, sir.
What's your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court accepts your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Ms. Tranter, anything before I pronounce the sentence?
Nothing further, Your Honor.
Mr. Guyman?
No, Judge.
Mr. Walton, is there anything you'd like to say, sir?
No, sir.
All right. The court has considered the purposes and the principles of sentencing, the relevant seriousness and recidivism factors The court does find that the defendant is not amenable to community control and that prison is necessary to fulfill the purposes and the principles of sentencing, including punishment, deterrence, and protection of the public. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So on the illegal conveyance, the court will order you to serve 9 months in prison, and on the aggravated possession, 6 months in prison, not to be served consecutive to the 2763 charge. Both of those sentences are also ordered to be served consecutive to your current sentence. The court does find that the consecutive sentence is necessary to punish this defendant. It is not disproportionate to the conduct or danger posed by the defendant, and these offenses occurred while the defendant was already incarcerated with the Department of Corrections. On these, you have 0 days jail time credit. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you're also subject to this discretionary post-release control. Do you need me to go over that with you again?
No, sir.
All right. There may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. Do you have any questions for me? No. All right, good luck to you, sir.
Thank you, Judge.
These are case numbers 25CR42948, 25CR43081, the State of Ohio versus Jerome Wade. Mr. Wade is before the court with his counsel, Ms. Diefenbach. Ms. Nicholson is here on behalf of the State of Ohio. Ms. Nicholson, what are we doing?
Your Honor, it's my understanding that as to case ending 948, the defendant will be entering a plea of guilty to count 1 and count 3, and the state will be dismissing count 2. As to case ending 081, it is my understanding the defendant will be pleading guilty as charged. And then we will be getting PSI. I know we discussed in chambers the matters pending in Cuyahoga County.
Logistically, how are we going to do a PSI if we're releasing him?
Well, I know Cuyahoga County has a holder. We also have a monitor requirement as a condition of his bond. That is what has previously returned him to this county. He has dealt with, he previously in August went to Cuyahoga, did about 3 weeks in Cuyahoga before returning ultimately here, and has not been able to satisfy the monitor requirements. But I think it will be difficult for this court to issue an appropriate sentence without understanding what's going to happen in Cuyahoga County, as he currently is facing significant charges in Cuyahoga. I know Ms. Diefenbach has spoken to his attorney up there, and there may be a reduction in those charges coming. And I think we need to know that to determine an appropriate sentence.
All right, Ms. Diefenbach, is all of that stated accurately?
Yes, sir.
All right, Mr. Wade, they're telling me you're going to change your plea to some of these charges. Before we get to that, I'm required to go over some things with you, okay? How old are you?
20.
How far did you go in school?
I graduated high school.
Can you read and write?
Yes.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you on these charges?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation you've received from Ms. Diefenbach?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
All right, I have in front of me 2 sets of documents. The first set under case number 42948. On the second page of this document, on the line marked defendant, there's a signature. Did you sign this?
Yes, sir.
And you read it, went over it with your attorney?
Yes, sir.
And you feel like you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of receiving stolen property as a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The prison term is not mandatory. The second count is one of obstructing official business, a misdemeanor of the 2nd degree. That carries with it a maximum penalty of 90 days in the Warren County Jail and a $750 fine. The second document I have under 43081, again on the second page of this document, on the line marked defendant, there's a signature. Did you sign this?
Yes, sir.
And you read this and went over it with your attorney?
Yes, sir.
And you believe you understand what this document says?
Yes, sir.
This one says you're entering a plea of guilty to one count of possession of a deadly weapon while under detention as a felony of the 5th degree. That also carries with it a maximum penalty of 12 months in prison and a maximum fine of $2,500. And once again, the prison term is not mandatory. Do you understand the maximum penalties involved?
Yes, sir.
On both cases, you are subject to a discretionary period of post-release control, which means that if you are sent to prison on these charges, upon your release, the adult parole authority may supervise you for up to 2 years. If you violate those terms of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, I do.
But it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes.
This is how you want to proceed.
Yes.
Ms. Nicholson.
Your Honor, if these cases had proceeded to trial in case ending 948, the state would have proven beyond a reasonable doubt that on or about August 15th, 2025, the defendant was in a vehicle that was stopped for multiple traffic violations on southbound I-71 in Union Township, Warren County, Ohio. The defendant initially misidentified himself as a juvenile and claimed he did not know his social security number. A probable cause search was conducted of the vehicle due to the odor of burnt marijuana. There were a number of credit and debit cards identified or located, as well as membership cards, social security cards, driver's license, etc., none of which belonged to any of the occupants of the vehicle. Some of those cards belonged to the charged victim, in this case, Denisha Mapp. She had filed a police report in Cleveland in April after her wallet was stolen. The defendant finally identified himself, took ownership of the backpack where a number of those items were found, the credit cards and things. He said, "That's my bag and my box." He had a felony warrant at the time. In the case ending 081, the defendant was incarcerated at the Warren County Jail on the F5 receiving stolen property charge on October 6th of 2025. And at that time, in his property box at the jail was a makeshift sharp weapon that was made from a toothbrush and a silver spring that had been fitted together and then wrapped to make a sufficient handle for holding the weapon.
Ms. Tiefenbach, anything on those facts?
No, sir.
Mr. Walton, did you hear the statement that she read? Did you hear what she said?
Yes.
Do you acknowledge what she said is true?
Yes.
And again, you understand all the rights you're giving up entering a plea of guilty, the rights we discussed?
Yes.
What's your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights we discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I am going to order a pre-sentence investigation. Mr. Wade, so my understanding is you're charged with an F1 aggravated robbery in Cuyahoga County, correct?
Correct.
And it's Ms. Diefenbach, it's your understanding that there's going to be some plea bargain offered or plea negotiation where this is going to be reduced to a low-level felony?
Well, actually, he's got one F1, two F2s, one F3, and then the F5. And apparently, from what I understand, they've got some evidentiary issues with the gun charges. And they're allowing his co-defendant to plead to the F5, and they're going to offer him the same deal.
All right. Mr. Wade, I know you're not from around here. You are from Cleveland, is that correct?
Correct.
Where'd you go to high school?
I went to the Cleveland School of the Arts.
Do you have an artistic talent?
Yes.
Doesn't seem like you're using that talent, does it? All right. I'm going to change your bond today. I'm going to release you on your own recognizance. And what that means is, my understanding, Cuyahoga County has a holder on you.
Correct.
So they're going to come pick you up, take you back up to Cleveland. Now, I'm ordering a pre-sentence investigation, so you're going to need to reach out to court services down here. Can we get him a number or something that he can call? Yeah, get him a number for Sarah. And you're going to need to kind of, even if you have to do it over the phone or something, but you're going to have to do this interview and this assessment, okay?
Okay.
And you can get the assessment in Cleveland as long as you sign a release of information so that our probation department can get that information. And then when if you get released from Cuyahoga County, you're going to come back here, right?
Correct.
You're promising me you're going to come back.
Correct.
The reason I'm going through all this with you is because you're so young, 20 years old, and you've already got felonies pending in 2 different counties. Well, they're not even pending here anymore. You now have a felony record, right? So you need to make some changes in your life, son, right?
Yes.
You got your entire future ahead of you, and here you are wasting away months at a time in jail. You don't want the rest of your life, do you?
No.
Then use this as a stepping stone to get something better for your life, okay? I'm going to trust you. You're promising me you're going to come back. You know, if you don't, what can happen, and I take it because of what happened at our jail, that you at least must have some fear of going to prison, right?
Yes.
I mean, if you had that device in your possession because you were afraid there, prison is 1,000 times worse, okay? I'm just cautioning you. Don't go there. Make some changes in your life now, okay? Will you?
Yes.
All right. So Justin's going to give you a phone number for you to call to do your pre-sentence investigation, but I am going to order you released today. Okay? You're going to come back, right?
Yes.
Okay. All right. I'll see you in a few weeks.
Yeah, I'll get it.
I'll see you in a few weeks.
Thank you, Your Honor.
Yeah. You have to make that
You done?
contact.